Man, kindly permit to complain office objection. Just for memo, man.
What is that for?
SCSC Act, man.
Hmm?
SCSC Act. Redetermination, man.
Check up. Is that what it is?
Sir, memo first. Memo for Postal. Redetermination 2023.
This is our postal. See our listing. Posted when will you post it? Fine. We have not heavy now. Just check up.
Hello.
Just give.
Balloons are seeking a shot at you.
There was. My lords, there was an interim order, my lords, and auction has taken place. We have deposited 20 lakhs. Then too, they are proceeding with sale agreement.
What is the matter about? What is the matter?
Sorry, my lords.
You know, is it an RFA?
DRT,
DRT.
DRT, man.
DRT.
Yes.
Is it pending matter?
Yes, man.
Just take it.
Kindly have it tomorrow.
We'll see it. Let's just have it a shot.
Sorry, 88.
We're filing a memo that order passed by Central Government Industrial Tribunal. So they have passed an order.
1 minute, please. Just 1 minute. You told him?
Yes.
Yes.
So Central Government Industrial Tribunal had passed the order on 28/4/2020, and we had filed a writ petition. We have sought for an interim order. That's a urgency, and we requested to proceed on tomorrow, my lord.
What is the
LRS.
What is the urgency?
That we have sought for interim order, and that order is pending in this one. They were.
Why is it being returned?
Session labor.
Okay.
My lords, this is a memo for fresh matters, my lords. In this, we are challenging.
Sir, what is the matter?
The matter is like illegal demonstration was being held in the institution premises. So there was charge sheet has been issued to the concerned persons, and it has been challenged in the CAT, my lords.
Appeal. Is it a writ appeal?
Yes, my lords. No, my lords. Writ petition. We are challenging the Central Administrative Tribunal order. We are on behalf of the institution, my lords. The connected matters are coming up on 12th, my lords. So kindly these matters also be posted on 12th, my lords.
12th, have it on.
Obliged, my lords.
Yes.
Writ petition, my lord, land grabbing act, the maintainability of it has been challenged. There's no interim order. The court is proceeding with the matter. It's filed at the instance of a stranger. It's not even initiated by the authority. Seeking some interim orders, my lord. 8th or 9th, my lord, this week, Wednesday or Thursday.
Just see it. Just see it.
My lords, I've filed a writ petition.
Grateful.
I filed a writ petition challenging the order of a DRAT. My lords, the auction purchaser is trying to dispose of the property. I had requested for an interim order. Interim order was not granted. It's a pending matter.
But not granted DRAT.
My lords, DRAT order I have challenged, my lords. DRAT dismissed my appeal mostly only on a ground of limitation. So I've challenged the order of DRAT.
Pre-deposit also.
My lords,
You are not.
no, my lords, there was no.
Are you?
I appear for the guarantor, my lords, who was the guarantor.
Just listed there.
My
Just
lords,
see it.
shortest date possible. Please, please, my lords.
Yes.
My lords, the memo for posting, it is
Matter about me.
intercharge transfer. It is about
Sir,
charge transfer matters.
is it against a tribunal's order?
Sorry, my lord.
Is it a writ appeal or a writ petition?
Writ petition, my lords.
Challenging the tribunal CAT order?
Yes, my lords.
Listed.
So it might be connected. Tomorrow it is listed, my lord.
Which one?
Writ prop.
Is it a connected? Is there any connected?
Yes,
matter
my
pending?
lords. Connected.
Just have it.
Thank you.
6,
The opinion ಮಾಡ್ಲಿ, whether it is possible to have registration of the document.
ಅದೆಲ್ಲ ಬಿಡಿ chain of technique.
ರಾಜಾಜಿನಗರ DRO ಅಂತ ಇದೆ. ಓಕೆ ಅಲ್ವಾ ಅದೆಲ್ಲ?
Here's call the list.
My lords, could I ask for an adjournment, my lords?
Serial
Let
number
us-
20, my lord.
For adjournments, page number 5, 15 to 17.
Number 23,
My lord, serial number 18, my lord.
17.
My lord, serial number 19, my lord. Serial number 19 in the first list.
We can hear only one at a time, please. Start from here.
Page number 5, any adjournments? Page number 6.
29.
Yes,
What, yes.
kindly have next week.
Pardon?
I am for the petitioner in this matter.
Yes.
Kindly have next week, one.
Why?
Some inconvenience.
What is the, you are the counsel to argue.
Petitioner, my lord, senior engaged in another court for that reason.
We will look, we'll try to accommodate. Let the matter be called. Yes,
Serial number 20. my lord.
yes.
From the other side, senior counsel, please, my lord, is unwell.
Who is unwell?
MV Chandrasekhar Reddy.
Okay. Who is the other side? Have you
I
informed
have
them?
informed, my lord, I have informed through phone.
We have been informed, just take this, we have been informed that Mr. MV Chandrasekhar Reddy, the counsel for the appellant, is unwell. If that be so, comma re-notify on. Yes.
My lord, serial number 23, my lord.
My lord. My lord, serial number 17. I'm for appellant. Can you please stand?
Yes, ma'am.
Respondent in this
And-
case, 1 to
Yes,
3.
ma'am.
I'm for the respondent 1 to 3.
You appear for all?
1 to 3, man.
What is the difficulty?
Some scene is not well.
What?
Some health
Who
problem.
has to argue the matter?
Senior.
Who is the senior, Mr. B.S. Ravindra?
Yes, ma'am.
Does he have any difficulty?
Yes, my lord.
What is the difficulty?
He told he's not well.
Adjournment is sought on the ground that Mr. B.S. Ravindra is unwell. Adjourn to.
Serial number 23, my lord.
Just one.
29, madam.
Just take the date.
Madam, 29.
Which number?
Serial number 23, list number 1.
Much.
I
23.
am for the appellant, my lord.
23.
I file wakalat on behalf of the respondents, my lord. Serial number 23, my lord. I am
Huh.
for the appellant. My lord,
Yes.
this matter, my lord, there is an amicable settlement is going on. So negotiation is going on, my lord. It may be referred to mediation, my lord. We will settle the matter.
You want for mediation?
Yes, my lord.
Yes, show us the file.
And government advocate may be directed to take notice on behalf of.
Eight to 13, I file wakalat, my lord. 4 to 13. Settlement ಮಾಡ್ಕೊಳ್ತಾರೆ. Land transfer. Nine. ಹಾಕಿದ್ದೀನಿ. ಕೋದಂಡರಾಮ.
Are you settling? You are also involved in the state is involved or who are involved?
Well, only the private properties, it was reminded to the,
Who appears for the private parties?
we appear, my lord, the respondent which Raju represents now.
I am appearing for the,
Aja, for the private parties?
please.
Yes, my lord, private parties.
Okay. At the request of the counsel for the appellant and the counsel appearing for respondent number?
4 to 13, my lord.
No, there are no 13 here. Two also? No.
To
4
Bharatiya
to, 4 to
Government
13. Who have 4 to 7?
4 to 7, my lord.
4 to 7. Who appears for the state? You appear for the state. 4 to 7, comma, re-notify.
My lords, serial number 18, my lords. I'm the counsel for the appellant due to
27,
not feeling well.
Yes.
Serial number
22, my lord.
Yes.
Serial number 22, my lord. I appear on behalf of the appellants, my lord.
Senior who is on the record is not feeling well, my lords. May I pray for 2 weeks' time, my lords?
Adjournment is sought by the counsel for the appellant on the ground that seniors is unwell.
Please, my lords.
Unwell, full stop.
My lords, serial number 18, my lords. I'm the
Yes, 1
counsel for
minute,
the appellate.
please. You allow
Sorry,
us
my
to,
lords.
1 minute, please. The counsel for the party shall file the written submissions along with the judgment they want to rely upon 1 week before the next date of hearing. Re-notify on.
11/9.
Yes, now tell us.
My lords, serial number 18, my lords. I'm the counsel on record for the appellate. It's a writ appeal, my lords. I'm not feeling well.
Item number?
Could I seek a serial number 18, my lords?
Yes.
Yeah, I'm the counsel on record. I'm not feeling well, my lords. Could I get a short adjournment, my lords? Next week, the date could also be fixed. if
What
not
do you,
the case.
why an adjournment?
My lords, I'm not feeling so good. I have a running nose, my lords. I'm not able to come. I'm the counsel on record, my lords.
Yes, what is the difficulty?
My lords, I'm the counsel on record. I have a running nose, my lords. I'm not able to come to the court today, my lords. That's why I'm seeking a short accommodation.
No, you have a bad throat.
Yes, my lords. That's why I myself have appeared on the VC, my lords.
Request, the request of counsel for the appellant.
Obliged, my lords.
My lord, serial number 15.
Yes, 1 minute, please.
My lord,
Sir.
Yes,
serial number 19, my lord.
Serial number 15.
yes.
Serial number 19, my lord. Pray for week time, my lord. Senior is not well, my lord.
We will just see. We will just see. Let's see that.
My lord, senior is not feeling well, my lord.
Okay, okay. See, you had only moved this application, the appeal for listing.
He unfortunately is not feeling well, my lord.
Okay, the council, the senior council is stated to be unwell, re-notify on 19.
13/9.
Lord, serial number 32.
Yes.
On record, my senior did due to some inconvenience, my lord, he had to go to his hometown. Look after his.
See, we can't, or if we adjourn all the matter, we do nothing.
My lord, a short accommodation. my lord.
It's all right. Now, why short accommodation? We are now listing the matters. We were ready to hear the matters.
Lord, just a short accommodation due to some inconvenience.
Why don't you argue?
Lord, sir, in fact, he informed in the morning.
It's not fair, you know. Adjournment is sought on the ground that the arguing counsel is out of station. Adjourn to.
17/9.
Serial number 15, my lords.
Yes.
My lords, parties have come to terms. Settlement is taking place, my lords. They have already agreed on settlement terms. I pray for my lords 2 weeks' time to comply with the settlement terms. That's all.
Then a counsel for the appellant rules appears for the respondent.
Respondent has already been informed, my lords.
Suhail
That
Ahmad.
the parties have settled their interstate dispute.
Please, my lords.
Principally have settled their interstate disputes. They intend to file the terms of the settlement.
Terms of settlement and to
within-
comply with the same, my lords.
Within 2 weeks.
Please. 15th.
Re-notify
Thereafter,
after 2 weeks.
28/8.
Lordship, serial number 16, your lordship. The
Grateful.
council on record, she has become a panel council, your lordship. PF, the matter pertaining to Provident Fund, your lordship. She has become a panel council. We have sent the letter to the client. So I will file the retirement memo, your lordship, kindly.
We know why at this stage.
Lordship, recently she has become a panel council, your lordship. Now we cannot appear in this matter. We have intimated the same council on record, Anu Bharadwaj. We have intimated the same to the client as well, your lordship. We will file the memo for retirement along with the letter, your lordship.
See, these things should be done earlier.
Please, your
You
lordship.
also go
Recent-
through the file.
Please,
You should
please.
have moved in any adjournment slip much earlier. I think we should start there. Adjournment is sought on the ground that the counsel for the appellant petitioner,
Petition,
Mr. Viresh Sangoli,
Anu Bharadwaj,
Anu Bharadwaj is not the counsel.
16, serial number 16.
Okay, Anu Bharadwaj, who is the counsel in writ petition number 25884, 2019. What about Mr. Viresh Sangoli?
Lordship, he is not working in our office, your lordship. No, earlier he used to work.
He intends to file an application for retirement. To stop at her request, re-notify on, just give it.
But
Serial number 16, is it?
Yes, ma'am.
I am appearing for the respondent.
16.2, she is seeking an adjournment. I think the counsel is now the counsel for the other side.
So
So
16
she's
point,
seeking a retirement.
16.1, 1 and 2 also.
We are ready to hear it. Now 16, tell us about 16 and 16.1.
I am appearing in for 16, Anu Bharadwaj, Your Lordship, counsel on record.
Then we will not adjourn 16 and 16. Just wait. We will not
Please.
adjourn. Let the council come in 16 and 16.1.
Please.
We'll take it up then. Yes, ma'am, start.
Serial number 1. Serial number 1.
I appear for the petitioner, my lord. I have filed this writ of habeas corpus, my lord. I am the father of a minor child. I stay in Behran. The mother and the child left without informing me. They are in India, somewhere in Bangalore, my lord. I am only asking for the production of the child, my lord.
But how an habeas corpus, ma'am?
My lord, I am not asking for the custody of the child. I do not even know the whereabouts of the child, my
No,
lord.
but sure, then habeas corpus would not lie. Huh? The child is with the mother.
No, I do not know whether the child is with the mother. Mother is not answering the calls at all.
Right.
From last 1 month, my lord, I have also filed a police complaint to respond number 2 and 3, the commissioner of police, but no action has been taken.
See, our whole case is only this. Now you say also you're seeing your son through video calls.
I used to see, my lord, from June 2014, I do not have any contact. I do not know where the mother is. I do not know where the child is.
What are your instructions?
The copy of the petition has not been served upon us, ma'am, to
I
look
will
into
serve
the
the copy,
matter.
my lord. Notice may be directed to.
The office objection is
Sign off.
also that the copy is not served to the
Subsection today
government.
itself.
So there are office objections.
I will
also.
comply with the office objection today.
One of
itself,
that
my lord.
is, my lord, that she has not served the copy upon on the government.
I will serve the copy.
This petition has been filed the following prayers. We find that as many as 16 objections have been notified by the registry. First off, let a copy of the writ petition be served on the counsel appearing for the state during the course of the day, who shall take instructions. Who shall take instructions. In the meantime, the learner counsel for the petitioner shall remove the objections as notified by the registry. Re-notify. When do you want?
Week's time, my lords.
Just say after a week.
13-8.
Obliged.
Serial number 2, Srimati Sumana Baliga. Sumana Baliga.
Coming on. Fourth time, huh? This issue is. You just say none for the appellant. In the interest of justice, re-notify all. Say last week in August.
30th of August. Serial number 3.
For the applicant. That's 200 rupees will be paid at the end of the day.
When will you remove the objections? You have to pay the.
Well, it's
court fee
just
also.
1 week. We will comply by all the office objections that are there.
You have not filed the application for condonation.
Well, we have sought for some documents which should be given to us very soon.
2
One
weeks-
last opportunity. my lords.
2 weeks are given to remove the objections.
Please, my lords.
Stop. Just 1 minute. If the objections are not removed, the appeal will stand dismissed.
We'll comply by it.
The appeal shall stand dismissed without referring the matter to the court.
Please.
Serial number. Serial number 4. Srimati Renuka.
For 2 weeks' time, Melvin. I'll comply with the office objections, my lord.
2 weeks, ma'am, tell her one thing. What is the otherwise issue on merit?
My lord, once the once the charge is held to be proved, my lord, the labor court cannot interfere, my lord, under section 11A. The matter is covered by the decision of the apex court in South Indian Cashews case. Here, my lord, the charges.
Which is the citation you are relying on?
My lord, it's reported in 2006, part 5, SCC, page 201. I've stated in para 10 of my writ appeal, my lord. My lord, it's a petition, my lord, under section 2K, my lord. And the
Tell her
charge,
one thing.
the charge is possession of excess cash. And the charge is,
Yes, let's come to the charge.
yeah, the charge is held to be proved, my lord. It's possession of excess cash.
Right, let's see whether that proving of the charge is justified.
My lord, in the corporate, my lord, even this issue, my lord, has also been the apex court in the case of my lord, case RTC, my lord, versus, my lord, I'm not getting the, I'm so sorry, my lord.
Now,
That
just-
petition, it is held, my lord, the possession of excess cash was 96 rupees. My lord, there's no
Would
fine.
you say this is an excess cash?
My lord, when the checking officials checked the bus, my lord, and the actual revenue was checked with the way bill, my lord, and this was in excess of it. There's a circular, my lord, in the corporation. They can carry any amount of money, my lord, with them. But before going online, they have to declare.
He didn't declare it?
No. The way bill shows, because there is a given cash check form is given to them, my lord. And as per the cash check form, my lord, they have to declare and get it certified by the traffic
So
control.
he didn't declare?
No.
So that's the reason it is an excess cash?
Yes. In all such cases where there is no
But
declaration.
Did you
And-
allege against him that you did not declare 302 rupees?
Yes, ma'am. That's the only charge is that we don't even attach, my lord, that it is derived of misappropriation. So it is
So you are drawing an inference that since he did not declare that, this is an excess
yes,
cash.
my lord. Because the conductors and drivers, my lord, will be in possession with the revenue of the corporation.
Just how much time to remove
My
objections?
lord, I'll do it in 2 days, my lord. Everything is ready, my lord.
Weeks time to remove objections, we notify all.
Fourteen eight. Serial number 5. Shri Mohan Reddy.
Appear for the appellant in this case, my lord. I seek 2 weeks' time to comply the office objections. I will take out the return of the IA, my lord, and also the comply the office objections.
This is item 5. Huh?
Finally, Your Lordship, fine.
2 weeks to remove the objections, re-notify.
Yes,
all. Let's give it in September, man. This is PTCL. 9th of September. 9th September, this is PTCL.
9-9. Sir, 9-9. Serial number 6. Shri Devi Prasad Shetty.
Lord, your Lordship may grant me. Lord, your Lordship may grant me 2 weeks time, my Lord.
See, you file second, the objections be removed within 2 weeks. Additionally, the learner counsel for the appellant petitioner shall file the English translation of the Kannada documents within the
And
same.
also
time
second
period.
set. And also second set. Earlier, it was filed before
Sir,
learns.
objections.
Please, please.
10-9.
It's a 14 matter.
Please, I'll do it.
7.
I prefer the.
Yes, Mr. Bhushan.
Lord, nothing survives in the matter, my lord. The reason is this, my lord. This, all these respondents have been retired now. So I don't think nothing survives in the matter. If your lordship may
Take
give.
a call. You want to withdraw it?
No, my lord, a week's time be granted, my lord. I will make my submission on that.
See, the issue was.
The issue was with regard to the prescribed age of 54 years as an outer limit for the state civil service officers to claim a stake for IAS as 56. The Supreme Court in the matter, my lord, refixed as 56 years. That was challenged before the tribunal. And now, my lord, the 2016 matter, my lord, they were about 57 years at that point of time. Now, my lord, nothing, they would have retired. The only thing which would.
Was under this order.
Please.
They require consideration. Will it not relate back?
That is the issue, my lord.
We don't know.
Please.
Although, very well, this is upper age limit, na?
Please.
Just take instructions.
Please, please.
The request of Mr. Shanti Bhushan, re-notify on how much time?
A week's time.
A week's time.
12-8, sir.
Great.
Serial number 8.
And for appellate in this case. In this case, the appeal is restricted only in respect to jurisdiction of the learned single judgment. I have challenged annexure L. That has been translated copy has been filed, annexure L.
Who appears for the Union of India?
For the respondent 5.
This is item 8 now. Shanti Bhushan.
He is my colleague. Shanti Bhushan is my colleague. I have sought only remand of the writ petition to the learned single judge. That is the only question before this honorable court. Therefore, other annexures need not be translated. Annexure L.
But you said this doesn't fall within the Karnataka Education Act.
Yes, my lord.
It falls.
No, it does not fall.
Does not fall.
Yes, my lord.
This Karnataka Education Act relates to which litigation or which
University Grant Commission.
No, this is also university.
Yes, my lord.
So then will it not go to the concerned tribunal, concerned authority under the Education Act?
No, my lord, there is some exception is there. Kindly
What's
see.
the exception? Let's see.
Yes.
the-
I'm appearing for the respondent 5.
Kindly see Karnataka Education Act, section 3, my lord. First page itself.
One submission with regard.
One.
Now, which are the exceptions?
Hey,
Let's see the.
Section 1, my lord.
Let's see the provision itself
Yes,
first.
my lord. May I refer section 1 of Karnataka Education Act. Before that, may I request your lordship to go through the order sheet, my lord. Here, my lord, section 1, short title, extent, application and commencement. Application of the act, here described, my lord. Kindly go to section subclass 3. It applies to all educational institutions and tutorial institutions in the state, except the exceptions are there, my lord. Kindly go to subclass 3 in that section, my lord. Institutions established or maintained and administered by or affiliated to. Kindly see annexure L, my lord. Now, it is very relevant. It is at page number 55 in page number. This is the order challenged before the learned single judge. Kindly see third line, affiliated to University of Mysore, accredited by the NAC with a grade. Now the post is assistant professor under UGC, my lord. This college is affiliated to Mysore University, my lord.
Please, UGC is the ultimate body which governs the standards of education in all universities.
Yes, ma'am.
That doesn't mean that this is a university under the UGC. Nothing of that sort. It is not a university under the central government, but it is a university.
University affiliated.
It is affiliated to a state university.
Yes, my lord.
That's enough.
Yes.
If it is affiliated to the state university, now see 131.
Yes, my lord.
Institutions of scientific and technical education financed by central government.
Central government.
This is not financed by central government.
No.
And declared by Parliament of Law to be institutions of national importance, like Jawaharlal Nehru University.
Yes.
It is such university which is contemplated. But insofar as you are concerned, this is a state university.
Yes, ma'am.
That's right. It applies to all education institution, territorial institution in state. Except those. So then this will fall within the jurisdiction of Karnataka Education Act. It will fall. Getting the point? UGC is only a regulatory authority which takes care of the standards of education all over India, including the state universities. But when it comes to the state university, we have to say whether it is a state university or a central university. This is affiliated to Mysore University, which is a state university. It get covered.
Oh, it is an except.
Exception is only those which do not fall within the state. Like central universities by the Act of Parliament, institutions of higher education which shall be deemed to be university as declared by the central government. It is not such a case. Institution established, administered, recognized the University of Agriculture Sciences. It is not a case.
Now, before that, Mela, kindly, institutions established or maintained and administered by or affiliated. This is very important. Or affiliated. This institution is affiliated to the Mysore University, Mela.
Affiliated or recognized by University of Agriculture Sciences.
No, it cannot be read with conjunction, Mela. Or means it shall be read with.
Let's test that argument.
Differently, Mela.
Let's test that argument. Then which university will get covered under this provision of 2 or 3? You tell us. What you are saying is institution established or maintained, administered by or affiliated to or recognized by the University of Agriculture. So what is intended is all those institutions which are recognized by the University of Agriculture, they are outside.
Yes,
and rightly so. That's a specialized agriculture university. Unlike normal university or normal institutions.
Yes, ma'am. Normal institutions will cover under the Karnataka Education Act. But this institution is affiliated to the Mysore University.
Not agricultural university.
Not agricultural university. I accept, my lord.
That's enough.
Then my submission before this honorable court is, it has to. It should,
go ahead.
It should not be read with conjunction, my lord. It has to be isolated, affiliated, or if there is then your lordship.
Let's see that. Institutions established or maintained.
Yes, my
lord. And administered.
Here and is there. There should be we shall read as conjunction. Here or is there. then it goes to the University of Agriculture.
So anything done by this, like affiliation, like established, maintained, administered, or affiliated to or recognized by University of Agriculture Sciences, they are outside. Simple. Is this university affiliated to Agriculture University?
No, no.
Then it's Mysore University.
Yes, my lord.
Will be.
No, that will cover. Mysore University will cover under, kindly see, sub-provision 4, my lord.
4. Let's see that.
4. Insofar as the matters pertaining to colleges and institutions are dealt within, kindly see D. The Karnataka State Universities Act. This Mysore University is covered under Karnataka Universities Act. Therefore, this subclass 4 within subclass D has to be read with subclass 3, my lord.
Very well. That's a well taken point. Now, are you saying that Mysore University is regulated by the Karnataka State University?
Yes, my lord. Yes.
Then you may be.
Yes,
You
amplifying the respondent 5, subsequent to the order of the single bench, they have already preferred an appeal before the competent authority. That is the secretary of the.
Yes, I have no other option. I have filed.
So they have already preferred based on.
Have they gone to that authority?
Yes.
Under the Education Act?
Yes, they have preferred.
Yes,
They've
my
gone.
lord.
Yes.
Why did you go?
Because I have filed a writ appeal before this honorable court. This honorable court, kindly see the order sheet, has considered this issue but not granted any interim order. Instead of, therefore, I have approached the authority. Kindly see the order sheet.
Now, is Mysore University established under the state?
Karnataka University. Yes, my lord.
State
Yes, my lord.
Yes, but our college, respondent number 5 college is an affiliated college under Mysore University. I am not. Mysore University is governed by the, it's a Karnataka State University Act, but not the colleges under the Mysore Universities. Private colleges, aided colleges under the private. So again, there is an exception.
No, but tell us one. Okay.
Yes. Of course, Mysore University is governed by Karnataka State University Act, but the private aided colleges governed under the Mysore Universities Act come under the Karnataka Education.
It is a aided institution, ma'am.
Yes.
Not purely private, aided institution.
Aided.
The post is UGC grant post.
See, you have that act.
I seek 1 week adjournment here. I was hoping that they'll file a memo with regard, because since they had appealed before the competent authority.
There must be judgments also on this
Yes.
now. See, why he is saying is this. Insofar as, now there is an exception. Now exception is insofar as the matters pertaining to colleges.
Yes.
And institutions are dealt within the Karnataka State Universities Act.
Yes.
Is it not a college? Is it not a college or an institution which dealt within the Karnataka State Universities Act?
No. Our college does not fall under Karnataka State Universities Act.
Your college may not.
Yes.
But as a Mysore state, now what is the issue which you have raised?
Appointment of the fifth respondent for the post of assistant professor. I have more meritorious than the appellant is more meritorious than the fifth respondent. Though they have appointed them, that has been challenged before the learned single judge. Learned single judge says that you have to go before the authorities under section 131 of the Karnataka Education Act. Therefore, I am before this.
Just one. See, he may be right. Why say we say is this. You see 3-4. Insofar as the matters pertaining to colleges and institutions are dealt within important.
Yes.
Indian Medical Council Act 1956.
Yes, ma'am.
Let's test this argument. Under the Indian Medical Council Act, all medical colleges comes.
Yes, ma'am.
Okay. But what is being intended is
Karnataka.
all those colleges which comes under the Indian Medical Council Act
Yes, madam, right.
are outside the jurisdiction of
This Education Act.
education.
Yes, madam. Like that, this college is affiliated to the Mysore University. Mysore University is covered under the Karnataka State University Act, Universities Act. Therefore, this act does not apply for my case.
So this requires consideration.
Subsequent to the order of the single bench, the respondent number 5 order has been confirmed and she continues to be in the, she continues to.
Though it is under challenge, they
Of
have
course.
dispersed the salary also, my lord, for the respondent.
See, we are only on the jurisdiction level.
Yes, ma'am.
Yes. With regard to the jurisdiction.
Difficulty is, my lord.
What is the stage there in the, before that authority?
Argument.
As on
Postal.
today, it has not posted for the argument. For one or the other reason, it is going adjourning. They have not considered my interim application. There was a interim order in the, before the learned single judge.
At what stage you had come here? At what stage you have come here?
At the stage of preliminary hearing,
After the order,
there was an interim order by the single judge.
We'll look into it.
Yes.
It requires consideration.
Kindly see the interim order passed by the single judge, my lord. Kindly see. In the impugned order at page number 12, my lord.
No, that we have seen.
Yes, here, there was an interim order.
6 weeks.
It was not continued. Due to, I have filed the appeal before the government. They have not considered my application for interim order. Now they are drawing the salary, though it is under challenge.
See, we'll
Subject.
tell you, this interim order was continued till you approach that authority.
Yes.
Yes, ma'am. I have approached.
No,
If they have not considered it, then
Yes,
you will
ma'am.
have a different grievance. That they have not considered it. But today we are only considering insofar as
Maintainable.
this maintainability issue.
Yes, ma'am.
We say nothing insofar as the continuance is concerned.
Yes. If we,
You went there, you did one, because it was extended for 4 weeks till such time you go there,
yes, sir.
not come here.
Yes, ma'am.
Getting the point?
Here also I have filed application to stay of this impugned order.
We will not create confusion. That authority has not given you the interim order, you are coming here. Otherwise, the remedy.
No, my lord. First I have filed appeal before this honorable court, then I gone to there, my lord.
We will consider it. We will consider in all, if ultimately, what is the interim order you sought? What is the interim order you sought?
Stay of this annexurial impugned order.
What does that annexure say?
Appointment of respondent number 5.
He is working now.
Yes, my lord. After filing of this petition, writ petition, my lord.
Today she is working. If ultimately you succeed, everything can be set aside. The benefits there can be given. That we will look into it.
in fact,
Then it will exchequer to the government. She will also draw the salary and they have to pay me also.
in fact, it's a conditional order with, along with the undertaking that is subject to the issue.
That protects your interest. The issue which falls for consideration is whether the issue raised by the petition appellant before the learned single judge shall fall within the jurisdiction of the Karnataka Education Act 1983. The submission of the learned counsel for the appellant is that in view of the provisions of section 1 of the Karnataka Education Act 1983. Just say
Yes.
subclause 3 of subsection 3 of section 1 contemplates that the grievance of the petitioner being with regard to the appointment of respondent number 5, respondent number 6 shall not fall within the provisions of Karnataka Education Act, as the subclause 3 is an exception. Subclause 3, subsection 3 contemplates certain exceptions, which includes insofar as matters pertaining to colleges and institutions which are dealt within the Karnataka State's University Act 1976. Since the issue raised by the appellant requires a consideration, appropriate shall be counsel for the parties to file the written submissions along with the judgment they want to rely upon. We appear for 4,
Respondent 5. That is the,
college.
the candidate who has been selected, successful candidate.
Candidate is 6, respondent number 6.
College is-
And 5 and 6, my colleague appears for 6 and then,
So you appear for the college also?
yes,
5 and 6. To file their written submissions
Yes.
along with the judgment they want to rely upon. How much time?
next week.
Within 2 weeks to re-notify, just give it in September.
Yes.
IA may be dispensed.
The learner counsel for the appellant does not press IA.
Yes.
For stay, na?
Yes.
Are you
Not
for-
stay, my lord. Dispensation application, translated copy to file.
See, we want translation.
No, annexure L is only for consideration before this honorable court. That has been filed. Translated copy of that annexure L is filed. Other annexures does not require. That is my prayer.
No, if you, is that?
It is unnecessary, my lord. It will get.
Have you filed the translation? That necessary, unnecessary, we will see it.
Please, man, please.
Have you filed the translation?
Yes, my lord.
You have filed it?
Yes.
That's it. It meets the requirement. Very well. Re-notify all.
11-9.
Much of.
Number 9.
Serial number 9, but Saturday, allot for the appellants, my lord. I want a 2 weeks time, my lord.
My lord, this is the matter wherein the connected writ appeal was dismissed, my lord.
Oh, yes.
And
This
nothing
is the
survives,
same.
my lord.
Then what remains in this?
No, that is different matter, my lord,
No,
and
my
it is not pertaining to the facts of the case of this appellant, my lord.
You tell us one thing.
Yes, please.
404
Yes,
In the dismissal agreement.
is similarly placed.
No.
Why?
Because, my lord, before the original authority, assistant commissioner only, there were 2 parties. And the assistant commissioner grants occupancy right in favor of one group, which was challenged by the appellant before your lordship in this appeal, before the deputy commissioner. The deputy commissioner has given the finding that the original authority, assistant commissioner granted the occupancy restoration in favor of.
Review petition.
And
Who
deputy,
appeared on the last date?
VB Shivakumar, I filed wakalat only Saturday.
When?
Saturday.
This is not.
I'm very sorry, my lord. I'm very sorry, my lord.
Everything last time we heard, they say so, and 404, and just come again, come to the impugned order.
Yes, please. Impugned order, my lord, that also, my lord, certain additional documents were produced.
Just, we are only on a simple issue.
Yes,
All these repetitions were heard together and passed a simple one simple common order.
yes,
Okay?
Yes.
Now, this order,
yes,
if you say C, page 57.
yes.
16139 and 17375 you filed these 2 petitions?
No,
Yes, ma'am.
File.
Yes, ma'am. Yes, ma'am.
404, 4402 and 4122 do not survive for consideration are accordingly dismissed.
Yes, madam.
404 against which order the appeal has been dismissed?
4408.
4402 and 4408, my lord.
Dismissed, and you
Yeah.
are now 1422, 2022.
Exactly.
That's all.
No, one
One
submission.
submission.
No,
For
they,
respond number 8, against the dismissal order, review petition is pending for consideration, Lordship.
Against which order?
Dismissal order. Review petition is pending for.
Is this order
Yes, my Lordship.
in 28 July?
Yes, my Lordship.
Was it, okay, very well. Now, was it filed after the dismissal of these 2 appeals?
Yes, my Lordship. Yes.
Till the date of.
Date of August.
They are doing. 3rd August.
Yes.
Then limitation also, my lord.
I file a limitation application.
How?
But when is the date?
3/8, my lordship. Date of
Filing?
Date of
But when is it?
Last week. Yes,
Has it been listed? The review petition?
Not listed. That is in the FR number. FR number 346.
Who had filed?
Last Saturday they
In
filed, my lord.
which
Yesterday, day
petition
before
review? In which
Sat-
petition you filed the review?
Against the writ appeal orders, my lord.
In which petition, which has been, see,
Yes,
review
but in
is
this- in this-
4408,
in this two- in this two-
4402,
In these two writ appeals.
4408 and 4402?
Yes, my lordship.
And this was after the last date you filed this review?
Yes, my lordship.
And very well, you also file in this. When you are filing these two, you will file it.
Already in this case, I am respond number 8 in this case.
We are only asking him.
He has
Simple.
nothing, no say there.
I don't think we should take it further. It may not be real.
No, one submission. This WP number 14122 of 22, you will have to make a 57 page number. That was a writ petition seeking direction to the concerned revenue officials to implement the order of the Deputy Commissioner. That is nothing to do with the WP number 4408, wherein they have challenged the order of the Deputy Commissioner and the Assistant Commissioner. This is why it's only seeking a direction to for implementation of that.
Let's see your prayer.
Let him see the.
Yeah.
Yes, ma'am.
But tell us one thing.
Yes,
This 16139 and 17375 gets allowed.
yes.
Even this direction for the deputy commissioner to consider would becomes also infructuous.
That is because, that will survive, my lord, because of the reason, my lord. The learned single judge has come to the conclusion that the lands were converted from agriculture to non-agriculture purpose by the land grantees. That finding is incorrect, my lord, because the conversion order was produced before the learned single judge for the first time. And that was obtained by the purchaser, not by the grantees. That aspect I have to bring to your lordship's notice. So as on the date of the alleged transaction, the land was not converted. It is subsequently the purchaser has approached and obtained.
Paragraph 14 and 15.
14 and
15.
yes, please.
Therefore, the writ petition filed by the purchaser.
Yes.
This reserves to be allowed if the order of resumption is liable to be quashed. The interstate dispute between legal heirs and original grantee Venkatappa Bovi in this do not survive for consideration are liable to be dismissed.
Yes.
Sheet 15.
Yes.
Consequently, the writ petition filed by the wife and son of Venkatappa Bovi in this seeking mandamus to implement the order of the deputy commissioner also does not survive for consideration, as this court has already quashed the orders of this.
Yes, now you'll ask me kindly see para number 11 for a moment, Millet. Para number 11. Relying upon the said order clearly goes to show that the non-alienation period indicated in the Sagvali chit issued in favor of Venkappa Bovi and Pedda Bovi expired on 1/11/76. Though the learned counsel appearing for the legal heirs of the original grantee have vehemently opposed to the taking cognizance of the additional documents placed on record by the purchaser relating to the conversion order secured by the original grantee. Even if the additional documents are ignored, the Karnataka appellate
Understanding, these are on merit. If 14,
yes,
the reasoning is 4402, 4408.
Yes.
Says liable to be quite interstate dispute between the legal heirs and the original grantee Venkatappa Bovi and this do not survive for consideration, then 15 shall automatically follow. It has to follow.
Yes, I understand, my lord.
All.
But unfortunately, my lord, this conversion order was not obtained by the grant.
See, we say nothing. The appeal insofar as 4402, 4408 was not successful.
No.
The consequence has to be 15. You're getting the point?
I understood, my lord, but the.
I have understood.
No, but writ petition number 4402 and 4402 are not on the same footing, my lord. The reliefs are.
It may not be, but if you see 14, read 14. One minute, please. 14, you read it.
Yes.
And 14 says followed by 15.
The coming to the conclusion in 14, my lord, whatever I read, my lord, the conversion order.
para 11.
Yes.
Huh.
That is if that document, that finding is erroneous, my lord, then this
That finding is also hold good for 4402 and 4408? Yes or no?
no.
Why?
Because before the Assistant Commissioner, my lord, the relief was granted to the petitioners in WP number 4408 and 4402. That I have challenged the petitioner in 14/11/22. The Deputy Commissioner reverses the finding of the Assistant Commissioner and holds that I am the legal representative of the original grantee. So that cannot be said read together, my lord, because their rights, the rights of the petitioners in 4408 and 4402 was extinguished by the order of the Deputy Commissioner. So my right and is protected by the order of the Deputy Commissioner. My lord, 1 week time may be granted, my lord, I will. Yes. Yes.
But tell us one thing.
Yes, please.
Now, you have prayed that seeking mandamus to implement the order of the Deputy Commissioner.
Yes, yes,
Okay.
yes.
Now, which order of the Deputy Commissioner has been challenged by 1613 and 17375?
Same.
Okay.
Same.
That order in the Deputy Commissioner
Yes,
may have inured to your benefit.
yes,
But what has been said is in 14,
yes.
that in 14, in this 16139 and 17375, the order of Deputy Commissioner also
Goes,
set aside.
goes. Then my direction does not survive.
That's right.
Yes.
So in 16139 and 17375, Deputy Commissioner's orders has been set aside.
Yes, yes.
That's right.
Yes.
If set aside, how will your prayer survive?
Yes, exactly, my lord. Now, your lordship read out 14, paragraph number 14. That conclusion was concluded by the learned single judge, relying upon the conversion order produced by the purchasers in the writ petition. It was not available either before the original authority or before the appellate authority. If those documents were available at the time, I would have led evidence contrary that it is not, I have.
Yeah, we are right. What we are putting it to is.
Yes, Lord.
Once this 4402, 4408.
Yes.
In any case.
Yeah.
In 16139 and 17322, the Deputy Commissioner's orders has been set aside.
Yes.
Okay. Then the court has said that because of this quashed,
Yeah.
the interstate dispute between Legal Aid and the Venkatappa Bovi do not survive. Because the Deputy Commissioner order has gone now. These 4402 and 4408 went in appeal. They went in appeal. That means the order of 16139 and 17375 has been upheld. Confirmed.
13.
Yes, ma'am.
By the
1613 and 17375 have been upheld
by the
as a division bench.
Yes.
In challenge against this 4402 and 4408.
Yes.
If that be so, how will this appeal can survive?
Exactly. That is my concern, my lord, because my interest and the interest of other petitioners are not the same, my lord. If it was same, I was also placed like the others.
Let's see the direction in writ petition number 1713. It says so. Therefore, writ petition filed. Let's see.
By the purchasers.
We don't know. We want to going by the directions in para 4. Yes. See the first paragraph 47.
47. Yes.
The petitioner who had purchased the land in question in an auction conducted by the Bombay High Court had filed 2 petitions. This is feeling agreed by the order of resumption passed by the respondent number 2 Assistant Commissioner and confirmed by the respondent Deputy Commissioner.
That is fit wrong.
Huh?
That was not confirmed by the Deputy Commissioner, my lord.
Who?
The Deputy Commissioner has given has reversed the order of the Assistant Commissioner.
Has reversed the order of
Yes. Granting occupancy right in favor of petitioners in 4402 and 4408, that is reversed. So this is
okay. Okay. Now they have been granted in favor of 4402 and 4408.
No, it was original authority has granted in their favor. Appellate authority reversed that finding and granted in my favor.
Now, 16139 and 17375
Yeah.
have been passed by, has been filed by the
Purchasers, subsequent purchasers, man.
subsequent purchasers who were agreed by the order of.
Yes, Assistant Commissioner and Deputy Commissioner.
Directly
They have granted it back to the grantees, my lord. That I have come.
4402 and
My
4408.
lord, I have a small synopsis, my lord. Some three.
Directly file a writ petition
Yes,
without
sir.
challenging the assistant commissioner order.
Yes, madam.
Both order has been challenged before the single judge. They did not challenge the assistant commissioner before the deputy commissioner.
May seek 1 week time, my lord, for my
To
satisfaction,
understand the thing,
for my.
because we have heard on the last date also.
Because I appeared before the Deputy Commissioner, my lord, so. My lord, the first page, my lord, dates are there, my lord. This is regarding, there were 2 parcels of land, my lord, 4 acres, my lord. One is 19, my lord, this is regarding this land, my lord.
Yes.
Very small synopsis, my lord. My lord, 30-10-1961, my lord, grant was made in favor of Venkatappa Bovi, son of Ram Bovi, my lord. 1/6/1961, Sagoli chit was issued. From there, the timing for 15 with 15 years non-alienation clause, my lord. My lord, from there it is, next is grantee applies for conversion of the land to industrial purpose, my lord. My lord, government grants permission to even purchase the land. Assistant Commissioner is given permission to purchase the land, my lord. First sale is after 15 years, exactly after 15 years, 511, my lord. It is 111, after 111, 511 is 15 years, my lord. My lord, land was converted to industrial purpose, my lord. My lord, PTCL Act comes into force, my lord. My lord, here I will rely on only 2 judgments of this one. My lord. Madam. Sorry.
See, we have failed to understand once the order of the deputy commissioner or the order giving the benefit to the original grantee has been rejected in favor of the purchasers, then what right survives in your case also? Nothing. You are seeking that deputy commissioner should decide.
No, that is what, your lordship, I kindly say the primary thing, my lord, the original authority has passed an order. That was not challenged by the purchasers. Only the rival claimants have.
Only the
rival claimant, my claims, have preferred appeal before the Deputy Commissioner. The purchaser has not challenged the original order of the authority. If it is
filed directly a writ petition.
Yes, sir.
Both of you.
Yes.
It's all right. But the writ petition has been decided, the appeal against them also rejected.
Yes.
You're getting?
I understand.
You may had all these pleas available before the learned single judge. But still fact remains, learned single judge, considering all the cases, has passed an order allowing writ petition 16139 and 173/2002 and rejecting the writ petition 4402, 4408. Now 4402 and 4408 is intersay the legal heirs of the original grantee Venkatappa Bovi. Are we right?
No, they are not. Because they will.
We are saying interstate dispute between the legal heirs of Venkatappa Bovi.
Right.
Now you have also filed, you are also the legal heirs of Venkatappa Bovi. That's right. Now when the rejection with regard to interstate dispute between legal heirs has been rejected 4402 and 4408, against which they went in an appeal also, that has been rejected. Based on that, your 14122/2022 was rejected. Then what survives?
Yes, exactly. Now, your lordship may kindly see, if the learned, if the learned single judge has passed the order on the available records before the original and appellate authority, then it is binding on me. I cannot say anything. the purchaser has produced certain documents in the writ proceedings, which was not, even though we have objected for production of such documents, the learned single judge has ignored that objection. And
That we can't look into.
no, one more subject. And another aspect, my lord, this land was re-granted in the year 1970, my lord. And the persons who are the legal representatives have made application for conversion of the land that was rejected. Those documents we were unable to produce.
No, 1 minute. Will that, whatever you are saying,
Yes.
will have a bearing on 4402 and 4408?
No.
Why?
Because if they were to be held as the legal representatives, and then yes, madam.
It has been held so.
No.
Interstate dispute between legal heirs of the original grantee.
No, the deputy commissioner's order clearly says I am the legal representative, not the other persons who are the petitioners in 4402 and 4408. If it was only among the members, I can understand. The deputy commissioner declared that I am, appellants 1 and 2 are the legal representative, not the others.
Okay, very well.
Yes.
Let's assume for a moment that, let's assume what you are saying is right. But once the deputy commissioner or once the learned single judge has granted in favor of the purchasers, what right the legal heirs would have?
No, if your lordship holds, my lord, my appeal is maintainable and I am entitled for the relief from the grantee, then that will go, my lord. The order passed in the writ petition of the purchasers has to go. Because when they accepted the court order of the assistant commissioner and they have not preferred appeal before the appellate authority under the statute, then they cannot bypass and file a writ petition. So in this regard, I will realize some judgment. 1 week time may be granted, my lord.
But you
yes.
see your prayer.
Yes, my prayer is seeking a direction, my lord, nothing
But
else.
you are not challenging your order of dismissal.
He's not challenging, he's not challenging.
You have not challenged your order of dismissal.
Yes.
See your prayer in the appeal.
He's not challenging. Inquest 32, more 30,
See, page 32.
32, sir.
See the prayer. So,
If the,
we have not challenged your outcome.
no,
And
others-
against that, where is that appeal was filed against 16139 also?
no,
Did you challenge that?
No. No, 16139, I have succeeded, my lord.
Oh, you have succeeded. No,
Yes,
this
my lord.
4402 and 4408,
He has only filed against those two, my lord.
he has filed only in these two.
Yes, my lord.
But you did not challenge your order. That has
Yes.
attained finality. There is no appeal against 1412122.
no, if this order goes, my lord, obviously.
Can you tell us how? Your writ petition stand dismissed. That's all.
No, if the order in favor of the purchaser goes, my lord, I think
You tell us how. Your claim has been rejected.
no, my claim, you will ask me kindly have it. My claim was only seeking a direction. That will not take away my right.
Why not? Today it's as good as your direction to for deputy commissioner goes.
No, if this order goes, my lord, then only direction, it may, deputy commissioner may take his own time, my lord.
See, what he's trying to draw is
Yes, my lord.
4402, 4408 are not legal airs.
My lord, whatever it may be, my lord, but the order of the single judge was challenged, my lord. It was challenged, my lord. He has also filed a writ appeal, my lord. He is challenging the same order, my lord. Order in that case has been passed, my lord. It covers this.
Dismissed against this appeal.
Same order.
No, my lord.
See, it's simple. 4402, 4408, those were the appeals against those orders, those.
Yes, my lord.
Where is that order? Appeal order rejecting
DC's order, my lord. Deputy Commissioner.
the appeal order where against this common order, they went in appeal. No? That's what you have said.
Yes, my lord. Yes, my lord.
Where is that order?
My lord, without notice, it was dismissed.
Memo जो था किधर लव सर बोले
Your lordship is asking the petition, my lord.
What was represented on the last date? See the last order.
Yes, my lord.
we
Yes, my
have
lord.
passed.
Yes, my lord.
We have said has filed a memo wherein the following has been stated.
Yes, my lord.
So now this order, common order passed by this, the response, this honorable court whether has dismissed the said appeal.
My lord, the judgment, my lord, intra-court appeal is directed against single judge.
अरे
order.
अरे कोटी कापी दिया
Court, last time court.
So what
Anigal
you said is, let's see that last order, your memo reads.
I have, my lord.
Number 9 submits that learner single judge by order dated 28/7/23 have passed a common order in writ petition number 1422.
Yes,
The other connected matters, writ petition 4408, 16139 and 17375.
Yes, ma'am.
The respondent number 3 and 4 in the writ petition have filed the above appeal and the respondent number 8 have filed WA 404. This court wide order dated 27/3/2024 has dismissed the said appeal. The copy of the order of 27/3/24 in writ appeal number 404 is produced herewith for kind perusal.
Yes, ma'am.
Now, this 404
Yes, my lord.
was filed against which order?
Same DC's and AC's order, my lord.
Huh?
Assistant Commissioner and Deputy Commissioner, same order, my lord. My lord.
We are on writ appeal.
Same, my lord. Single judge's order, my lord.
Single judge order in both the writ petitions.
Yes, my lord. All the 4 writ petitions, my lord.
It's a common order.
Yes, my lord.
But was it in which appeal, in which writ petition that was filed?
My lord is filed.
4402 and
4408.
4408 my lord.
Okay. And 14122
was by him.
you have not challenged.
That is what this appeal.
It is not see the prayer.
A prayer.
It's not. So what is being challenged is 16139. Where is your memo yesterday, last times?
Yes, my lord.
I don't think we should.
Well,
The last date of hearing, this court had passed the following. order.
one submission. It will be
Yes.
Friday.
Pardon?
Friday till Friday.
No. It's all right. Full stop. Suffice to, on the last date of full stop, the learner counsel for the appellant sought time to look into the same. Full stop. Though today the learner counsel for the appellant seeks time for making his submission. Since the fact that the writ petition was decided by the learner single judge, by a common order deciding 5 writ petitions. And the writ appeal against writ petition number 4402/2022. 4402/22 and 4408 or 22. As seen from the order passed by the division bench on 27th March 2024, has been dismissed, the present appeal which has been filed by the appellants challenging the order to the extent in writ petition number 16139/2022, but without laying a challenge of the dismissal of the writ petition filed by the appellants, is also dismissed. Thank you.
Sorry, man.
It's all right, you have done your job. You.
No, at the later stage, I filed Wakala, that's in this regard.
We say nothing, leave it
Please.
at that.
Please.
Thank you.
And I filed my Wakalat, my name may be noted.
We will note it. Just learn a counsel for the appellant, just note his name. When did you file his wakalat on record?
Saturday it was.
It's not there on record.
Yeah, please. Then it may be, no problem. Let it be, the other advocate's name may be shown well. We be sure one.
We will note your name.
Yes,
Just
please.
Just say the name. And
We wish,
you have already filed it?
yes, Saturday,
Wakalatnama.
Saturday I filed. Well.
Oh,
Please.
Serial number 10. Venkataraman.
My list would be there.
Serial number 10.
I appear for the petitioner, my lord. All the 3 times I have taken the process through the court. All the 3 times it has returned as not served. So I will take by way of a substituted service within a 2 weeks' time, man.
Issue notice, notice was issued in this.
Notice was issued, my lord, I have taken.
But how would you serve them now?
Now I will find out with the department new address. I will-
On the counsel for the appellant furnishing fresh address of the respondent. Notice shall be issued to the respondent returnable on.
Much.
10. 11. Serial number 11.
The respondent state, my lords.
We'll just pass over, Mr. Chowta. We'll hear you. Pass over.
For the petitioner in this case, my lord. This matter pertains to Dharwad bench, my lord. The connected matter is pending consideration before the Dharwad bench.
But how is it listed here then?
And it was long back because this writ petition came to be filed in the year 1992. And it came to be dismissed for non-prosecution in the year 1993. And
So
subsequently,
it was dismissed by this court only.
yes,
this
yes, my
bench.
lord. Yes, my lord. Prior to setting up of the division bench at Dharwad, it was dismissed and connected matter is pending consideration by the Dharwad bench.
Connected matter is here, there is a question of delay.
Yes,
When was it dismissed?
it was dismissed in 1993 and subsequently recall application CP was filed in 2001. That also came to be dismissed.
On what ground?
Non-prosecution only, my lord.
That's also non-prosecution.
Yes, my lord. That because what happened, they did not take process in the matter and it got dismissed automatically. 3 weeks time was granted.
But this need to be looked into here only.
Yes, my lord. Yes, my lord, but no records are available at this stage. File needs to be reconstructed in the matter because all the,
You appear for whom?
I appear for the petitioners in the writ petition.
The SSCs.
Yes, my lord. No, the persons who had applied for occupancy rights in respect of a survey number of land, two items of land in Jamkhandi village. What has happened? There are rival claims by the respondents.
Business 2 times. Becoming the applications also business.
You will say this. Taking the orders of the office. See this. This, all the appellants and the respondents are Bijapur.
Yes, my lord. Bijapur district.
So it comes under Dharwad.
Yes, yes, my lord. Filing memo also that one writ petition is pending consideration there.
This, just say this, these two applications have been filed, one of 24 and two of 24. Seeking recall of order dated 6/11/23.
One is 611. I have filed because in 2024, we filed an application for recall of the order dated 31/3/2001, my lord. That because of the ill health of the petitioner's counsel, he could not appear.
When was 23 dismissed?
On 6/3/2011, 2023. 6/11/2023.
Today we have to control this. Here's what we call in this. This is something good. This is only when this is allowed.
No, my lord, no, my lord. That is altogether coming from a different writ petition.
Right.
Yes, my lord. There are total 4 survey numbers, my lord. In respect of, yes, my lord.
On 6/11/23, there is an order of this court.
Yes, my lord. Yes, my lord. I
think the recall of 6/11/23.
No, no, my lord. We filed this application on 10/7/2020, 12/7/2023 to recall the order dated 31/3/2001. 2001 order we prayed for recalling.
This 6/11 has been dismissed.
Yes, my lord. That was on the ground of, there was a non-compliance of office objections.
Right. So we are considering for recall of this order.
Yes, my lord. Yes, my lord.
So this order has been passed by this bench.
Yes, yes, my lord. Yes, my lord. And therefore, I filed an application for recall of the order on the ground that the petitioner's counsel, Mr. Huded Gaddi, he is seriously ill, my lord. Recently, he has recovered. He was not coming to the court. He could not appear on that day. And also, in the cause list, my name was not shown, so I could not appear. Therefore, I pray for recall of the order dated 6/11 to 2023.
Just check up also in the registry. We'll have it after 2 weeks. Just check. We'll just re-notify it. Let's see that.
Yes, ma'am.
Okay?
Please.
Just re-notify. After 2 weeks, we'll have it.
Grateful, ma'am.
28/8, sir.
You have noted the date?
28/8, sir.
Grateful.
28th of August.
Yes.
Serial number 13.
Serial number 13, my lords, I appear for the appellant. I is for recalling the order dated 6/6/23 for dismissal of non-compliance of office objections, my lords. I had filed my application to recall the order.
But have you removed the objection?
These, my lords, we have removed,
All.
we have removed the objection. All the objections have been removed.
Does the report say? The objections removed.
This completes.
We complied with.
The earlier repetition, my name.
On 5/12/23, my lords, we were given time to comply with the objections and we have removed the objections, my lords.
These two applications, IA 1 of 23 and 2 of 23, are for the seeking condonation of delay in filing the 8 days delay in filing the recall application and for the recalling of order dated 6/6/2023. For the reasons stated in the affidavit supporting these applications, the delay of 8 days in filing the recall application is condoned. Where do you say 8 days delay?
My lords, I have filed an application,
Okay, it says 3 days delay.
8 days, my lords. It has been mistaken.
See your page, IA 1 of 24.
Lords, para 5 of the IA affidavit, my lords.
See the prayer. While filing the writ appeal.
Yeah, 1 of 26.
CD, okay, okay. 8 days. And also the application for recall of order dated 6/6/23. Which the application is disposed of. What is the issue here?
Lords, issue, my lords, is that I have been allotted a site, my lords. I was a successful bidder before the property allotted by virtue of BDA. The learned single, I
Now, did you get that refund?
no, my lords.
There is no order on that.
There is an order, no, there is no order by the respondents. The learned single judge made an order for refund. Only short issue before your lordships, my lords.
But tell us.
I was,
just-
I had, please, my lords.
But how are the now 4 lakhs given with interest?
It has been ordered, my lords, but I had two prayers before the learned.
Let's see those prayers come to
Please,
28.
That's at page number 28, my lords, of the appeal memorandum. My first prayer is to issue a writ in the nature of certiorari quashing the impugned order dated 3/7/2014. And B is to issue in the quashing the setting aside the notification of all further proceedings in pursuance of notification dated 11/7/2014.
Now,
Those two, my lords.
what is 3/7/2014?
3/7/2014 by Annexure G, my lords. That is at page number 81, my lords, where they have forfeited my 4 lakh refund. Of
That
the,
has been refunded.
no, I'll just place it before your lordships, my lords. There is one more prayer at Annexure C, also, my lords. Now.
So let's
issue-
see, A doesn't survive.
A doesn't survive, my lords.
B,
B, my lords. B is that they have initiated a fresh auction notice for the same site. Now, factually, I'll just briefly in one line, my lords, I'll finish off, my lords. There was a property in which I have participated for a measurement of 95.
we have got it, that we have got it.
Please, my lord.
Now, tell us one
The
thing.
discrepancy was with them. Immediately, as soon as I found that there was a discrepancy in some measurement of the site, I made a representation saying that, please clarify this. There was a 12-meter additional measurement of the site. When I went there, they appointed the survey engineers and found that there was an additional discrepancy error in these measurements of the site. Thereafter, my lords, either they should have taken a decision and asked me to say that, then again, they reverted back saying that it is only 95 now. After we removed the plants and scrubs, it is 95. So either they should have asked me to pay the refund of the amount, or they should have told that, no, see, right now we cannot do that, we'll cancel it. They should have refunded the 4 lakhs at that point of time. They neither did this nor did this. They said that for the same site, they again re-notified for the auction.
Did you apply?
My lords, I could not have applied because I've already participated. My issue before them is that either they should have asked me to pay the remaining amount.
But that's it now, that is, you can't really argue that. Once you have sought the refund.
My lords, initially, my lords, I was the one who raised the measurement because.
See, simple, against first notification.
Please.
Say, I don't want this refund. You make it for the larger area. This must be treated as.
No, there was no larger area.
Then why did you seek refund?
My lords, that is why, my lords. My cause of action was initially because if they had refunded at that point of time, I would have taken the refund, my lords. Now, my lords, I have been ready and willing till date. I've been ready and willing, my lords, to take up the site. It is that because of their mistakes, my lords, I have been made to.
What happened to the second notification?
Second notification was stayed by this honorable court.
Oh, that has been stayed.
Yes, that was stayed. It was not pursuant to that. Nothing was done. It was stayed.
The appeal or?
In the writ petition itself. Thereafter, I moved an application for early disposal. The learned single judge had issued a rule, my lords, on the matter, and it was kept pending for almost 8 years. In 2020-23, the order was passed saying that I'll be entitled for refund alone. I am till date, my lords. Today also, I'm ready and willing to take up the site. Except for their errors committed by the respondent BDM, my lords, I am ready. I am willing to pay the amount, whatever is.
What happened after the learned single judge judgment order?
Nothing. They have not proceeded to refund, nor they have not called me, nothing. And I have challenged this order because my petitioner, my lords, petitioner is a single lady who is working. And she is intended to take the site, my lords.
No.
And she's been waiting for this for the past 10 years.
You will listen
Please.
to the court also.
Please.
This 4 lakhs has come back to you?
No, my lords.
So after even the learned single judge order, nothing has been done.
Nothing has transpired, my lords. It is standing like this. My
So your case is this. Against first notification, they could not have issued second notification. Against that first notification against which you have submitted your bid, They should have offered to you
Please,
what? The same area of land?
same area, whatever was notified.
And why did you seek your refund?
My lords, that was as an alternative at the initial point I sought, my lords. Then
So-
when they said that it is on the same dimension, I said, okay, I'll take up. They should have given me an opportunity to submit the money and confirm the sale. But they did not do so. They said that, no, nothing doing.
You also did not seek the refund of 4 lakhs.
No, I will just,
Order.
I will just, please, my lords. No, I have not, what I have stated is, my representation as early on 26 February 2015.
Yes,
that
we
page.
got it. So you are not satisfied with the order of the learned single judge giving you 4 lakhs
No, my
with
lords.
interest.
No, my lords.
You say a much larger relief you are claiming,
Please,
which is in terms of B.
please.
Notice was issued to the other side.
Notice is not at risk.
Then we will issue notice.
Please, my lords.
Issue notice to the respondents. Returnable loan. Okay.
Please, my lords. Oblige.
Thank you.
110.
For the applicant.
14,
Which number, ma'am?
14.
This matter pertaining the Bangalore Development Authority, BDA, the IAs for dispensation of the preliminary notification and final notification, the translation copy has been, the certified copy has not been produced, so the certified copy is.
Have you filed the translation of all the documents?
Lots, only one, that is with respect to annexure C, which is the sale deed, lots, how the title has been.
There are
sourced.
other documents also.
Others have been filed.
You filed it,
Please, only one annexure C, lots, that's the sale deed.
that you have filed? No.
I have filed the type copy, the translated copy I've sought for dispensation. Rest everything I've filed.
So you are seeking dropping of that land from the acquisition.
Please, Lords.
But the committee says, no, it will form part of the acquisition.
Please, Lords. The difficulty, I've produced the entire layout plan,
How
Lords.
would you come over the findings?
I'll just hand over the. This is an extract of the layout plan that has been produced. The Lordship will see what has been highlighted in the pink. That's the only extent which has been acquired, which is the remaining land, leaving the 11 guntas of land, only what is facing the main road. In fact, the remaining land of 11 guntas has been left. The remaining land of 100/5, which is also belonging to the same appellant from the same sale deed, has been left. All the other lands around this said property has been left, except this one portion for 10 guntas facing the main road they have acquired. And if your Lordships may see the photograph produced at page 70.
It's not the reasoning. Reasoning is something different. You are not the owner of this.
In this, there's a dispute between the power of attorney holder, the sale deed, and even in fact, even till date, the suits are pending in the trial court. The petitioners have not executed any such sale deeds.
the parties have come forward and executed a reconveyance deed because there were some disputes between the parties. The Pani, that is the revenue title record, is been pending from 2003. That is, as on the date of notification, the Pani still is in their name, my lords. The revenue records, right from 85.
Revenue record doesn't say show title.
There's a dispute between the site owners who have acted upon the said GPA and the landowner. Even till date, the landowner is in possession and also is the person who's in a title by virtue of the RTC. The only issue is the disputes between the site owners and the landowners have been resolved. They've executed the reconveyance deed. As on today, the dispute that lordships, that would not be the ambit and scope what the committee could decide whether he's the owner or not.
Why?
Because as on that day, lords, the civil courts in the civil courts matter has been
The basis, the bottom line of this, the conclusion is that if you are not an owner, you can't resist the acquisition.
lords, as on that day, whether he was owner or not is a matter that has to be resolved by the civil suit. And in respect of these sites have not been alienated, lords. In respect of these sites, except 3 sites, what was alienated, that also has been reconveyed back to him. So even if the representations of the land, the site owners are considered, ultimately the adjacent land which has been left out, including if this land has been left out, it endures to the benefit of the person who has been, the sites have been reconveyed, lords. Because the sites have been reconveyed. Because there was some dispute with the GPA holder was executed the sale deeds, there was a dispute between the GPA holders, site owners and the landowner. And pursuant to the same, they've executed the sale deeds back in their name.
Whose favor?
In the appellant's favor.
Who are the appellants? They are the owners.
Appellant is a landowner, lords. Annexure C.
But was it projected in the manner now you are saying before the committee?
Yes, it was projected. The reconveyance deeds also is produced before the committee.
Then what is the finding on that?
The finding is that because
in the state. So it is vested in the state government. That's the finding and that's the position of law also.
as per the directions given by the lordship in the lords may see, the committee is constituted pursuant to this order. What is being also acquired is also been subject matter of this acquisition proceedings, which the committee has been constituted. Not only what is vested, your lords, not only what was dropped, which is also vested, has also been looked into as per the directions passed by this honorable court. The committee was constituted pursuant to the order of this court, your lords.
You have seen that.
Please, your lords.
No, we have
So
seen-
even if the land was vested, the honorable court has directed them to take a look at the land, but if it is either deleted or which was included as part of the acquisition, whether it's in accordance with law or not, because the representations have been produced, have been submitted long ago, stating that except this 10 guntas of land, everything around the line.
Are you saying that this order of the committee is contrary to at variance with the order by which this committee was
Please,
constituted?
your lords, the committee has directed them to even look at the lands which has been included also as part of the acquisition. And also 900 acres which has been deleted and denotified also has been part of the committee report. And your lords will see that only 10 guntas has been acquired in the main road. Your lords will see the photographs produced at page 71, 72 and 73.
Where is the judgment of the, by which the committee was constituted?
Lords, I have the judgment.
It is not so.
Lords, it's about 754
That's
pages,
right.
so lords.
No, but we require complete judgment, not like, see. we
Lords,
have to
I'm
see
sorry,
everything. There is a conclusion wrong.
Conclusion is at page
That
7.
In Bodu Ramaswamy, the reliance was.
That has been produced in entirety, your lords, in the
We
in the
want to
petition.
know what is the judgment says.
Lords, in the entirety, the conclusion is that recommendations, what the committee is considered, what it needs to be looked into is from page 745, your lords. At A and B, this comes under B, your lords, as well as D. Because this land was converted even before, in 91, your lords, even before 2003. And in D, one of the specific consideration is if the lands are converted, such lands have to be deleted, your lords. The conversion order also has been produced along with the appeal. And moreover, the remaining survey number in the same land has been deleted, has not been included, your lords. It's part of the acquisition. This is only because this is facing the main road.
Say the committee shall examine as to whether the claim of the landowners.
Please.
So who can now claim for deletion is only the landowners.
Plus, as on today, because the reconveyance deeds have been executed, in respect of 3 sites which is in dispute, the landowner will be the person who will actually claim on.
The finding of the committee on that.
Lords, in that, the honorable committee is not gone into, lords. I take your lordships to.
But what the committee says is, assuming for the argument, the subsequently the purchase of the site was executed. Cancelling the sale deed.
But ultimately,
might have acquired right over these sites only in the year 2013. What has been done is revesting, whatever you may call it.
Please, lords.
Was done in 2000, by which time the acquisition has become final.
Lords, the scope of the committee is including the proceedings that have been final also, your lords, because the scope of the committee is to also look into the acquisitions which is included, which is become final, including the lands which are vested. Your lordships will see the other recommendations that have been looked into. Para H, page 749. In the same judgment. The committee shall examine as to whether deletion of 983 acres of land by the government subsequent to notification dated 23/2/2004 and before issuance of notification dated so-and-so was in accordance with dicta laid down by the division bench and in compliance with directions and clarifications issued by the Honorable Court in Bondu Ramaswamy case and submit a report to the BDA and shall take steps based on the said report. So whatever even has been vested and acquired and concluded, the Honorable Court has directed them to also relook into all those acquisitions comprehensively by virtue of this committee, your lords. And since the 3 sites also has been concluded and the reconveyance deed has been executed, in respect of those 3 sites, if the said land has been dropped from the acquisition proceedings, since he's been reconveyed, the benefit of that will re-inure to the benefit of the land.
This committee report will be considered by the BDA?
Please, lords, that's the.
Just 1 minute. Now, can a writ petition at this stage lie?
Because, your lords, Annexure B. That's a problem, lords. Annexure B and Annexure D talks about the BDA should take an final action, whether it should be.
That's right.
But before that, the BDA has now started demolishing the land, your lords. Page 71, 72, and 73. In fact, there's other committee reports also, which I'm privy to, lots, but no action has been taken regarding those committee reports. This, we have no idea what they have taken, but page 71, 72, and 73. Lords will see, they've started demolishing the.
But mere demolition means that it is acquisition.
Lords?
Mere demolition means acquisition.
Lords, they've also put up a board with stating that it's BDA. Till now, they said property in subject matter of landowners. It's in their position. They've also been put up a construction and they've been in possession since that date. But now BDA, without any further notice or without any intimation, they've come and started demolishing using the bulldozers. And this is done on 25th, your lords. Lords will see on 72, page 72. They've almost demolished.
But the BDA has already allotted 3 sites, my lord, in which, my lord, the disputed land. But carried out, my lord, the sites as far. This, my lord, page number 34, my lord, 11, para 11, my lord. At this stage, it is brought to the notice of the committee by the BDA that the 3 sites formed in the person.
Show us, where do you say? Which paragraph?
Page number 34, my lord, para 11.
Huh.
My lord, I already crowd out, my lord, 3 sites in favor of, my lord, the allottees. In the case, my lord,
and we are concerned with this serial survey number 84/7.
84/7.
248, 252.
It's only in these three
But
sites,
it is
it's
for the
based.
media to take necessary immediately to take allotment to its logical conclusion by executing sale days and placing. You are the above.
BDA is not informed what action they've been taken pursuant to this committee report, but they've come with the demolition vehicles on 25th and they've started demolishing the compound and also the building. And your lordships will see in the photos, all the land around it has been developed. All other land is developed.
All other land is,
Developed, your lords. Except this, because it's subject matter of.
no, they have allotted for 323.
That is what the committee has to be looked into, Lord. So in case if the deletion is finalized, then that allotment has to be looked into with the other survey number which has been available, Lord. The 3 sites. Now the dispute is only with respect to 10 guntas, and the 11 guntas also is not subject matter of litigation, Lord. Your lordships will see the remaining land total extent of 84/7 is 21 guntas. They've only acquired 10 guntas, which is facing the main road, which doesn't make any logical sense. Why they only acquired 10 guntas? And that has a very high real estate value. What allotments?
10 guntas has not been acquired.
11 guntas has not been acquired, Lords. Your lordships will see. Your lordships will see the sketch. The extent below that, your lords, that there's a line running across. That's the remaining extent of 11 guntas. That's not been acquired. And also the lordship, the long 100/5, that also belongs to the same appellant from the same sale deed, Annexure C. Total extent is 3 acres, 28 guntas. They've only acquired 10 guntas, which is facing the main road. And your lords will see all around the properties have been left out from the acquisition.
You appear for
Respond number 1, my lord.
Urban development.
urban development. You don't require to send it to committee to be a party. Committee will not come and justify.
But in earlier petitions, they've made a party, they raised no objection. In fact, even we realized that there should not be a party. Because in earlier petitions, they've been made a party, we are constrained to make it. But I can delete them, Lord. Pursuant to this order, I'll delete them.
Was notice issued on this?
No, Your Lord. This is the first day, Your Lord.
There are no objections, no?
No, sir.
Because there was going to be objections with respect to respond number 4, and since there was threat of imminent disposition, Your Lord, so I was constrained to
What
file
is the
it.
disposition you are seeking?
Lords, they have, Lords will see at the photos, they've already demolished the compound and half the building, Lords.
No, dispensing with the document.
Dispensation, Lords, with the 2 preliminary notifications, Lords, the certified copy of it, page 36. The preliminary and the final notification.
36
And 43.
No, what was the objection with regard to these?
We have not produced certified copy of it.
The IA 1/24 is seeking to dispense with the production of complete copies of documents at pages 36, Annexure B, and Annexure B, they say 36 to which page? 46?
36 to, please, Lords,
48.
48.
48. For the reasons stated in the application, the same is allowed. Application disposed of. The learner counsel for the IA 2/24 is an application to dispense with the production of the translated copy of the sale deed.
Annexure C, Lords. Type copies at page 50.
C.
7. I can also produce it in due course of time, not a difficulty.
The translation of the same shall be filed
Within 1 week.
within 1 week from today. Full stop. Issue notice to respondents 1, 2, and 3. Returnable on, just gave in September also.
1610.
So also accept notice for 1, who shall file objections within 4 weeks.
PDA Malad contesting respond.
We have issued notice.
There's a threat of disposition of and they also demolition elements. They've already demolished a little bit. There may be,
That we will see it, not now.
it's very they'll demolish the property entirely.
We will see it here before the court.
At least let them maintain status quo with us.
No, we say nothing on. Let's hear it from them.
But by next date, they may just demolish the entire.
It's all right, we will hear you. Prima facie, we are the reasoning given by the committee.
No, I understand that, but the only thing is, the property may be.
The EP can, surely you are in an appeal. You are in a writ petition rather. We will look into it.
But the property may not be left there, Lords, by the next, because the BDA is, we have just taken 3 days' time from them, Lords, stating that we will approach the court, because we have not received any final report from BDA. In the meanwhile, they've come with and also demolished.
Then file their objection.
But portion of the.
How much time you want?
2 weeks, Malad.
2 weeks. We'll.
But by then, it's very difficult to, even complaints are not accepted by the police station, Lords.
No.
There's nothing much we can do against.
There is an application of mind by the committee.
Please, Lords. But since the committee report has been given, Lords, but the BDA has not decided the final thing, but they've come directly with the said excavation machines and also demolition machines. What property has been put up ultimately will not be, this whole writ petition itself has become.
There are 2 things. Committee applied, they have allotted also. That's the reasoning.
That's only with 3 sites.
We will, if you succeed, it can be set to not everything.
But again, the whole property will be demolished and BDA will never going to compensate that. The property, what is there on the site, they've already demolished quarter of it.
Your property, this is your constructor?
Please, Lords. I am only stating only with respect of that, Lords.
You come back after 2 weeks, we'll have it after 2 weeks. Please.
But at least let them not disturb the construction.
Nothing, we say nothing on that. We will look into it. See, there is the committee pursuant to the orders of this court applied their mind. And then we just wanted to know that they have applied, they have allotted to the 3 persons whom they have noted. We wanted to have the details of those ones.
But you also may also look into other factors, except leaving 11 guntas in the same land, they've taken 10 guntas in the.
You are right. You are actually right, saying that they have left the adjacent portion of the land and even at the backside also, while only this land facing the main road. That's right.
Please,
we just want to know why.
But at least let them at least maintain status.
Okay, we have expressed ourselves, please. Have it after 2 weeks, ma'am. 27, 28.
28.
Obliged.
Objections, if any, be filed within 2 weeks. Please, file your objections.
Fifteen Arjun, 16, Viresh Sangoli.
I appear for the respondent in
I
16.16 and 16.1.
Your Lordship, I apologize. Even in the other matters also, our office will be appearing, Your Lordship, but it is reflecting in the name of my farmer colleagues. Actually, my senior, Mr. Harikrishna Holla, is no more, Your Lordship. He recently passed away. So now the office is handled by Anu Bharadwaj. In fact, Your Lordship, this petition was filed in the name of Mr. Harikrishna Holla only, but now because it's reflecting in others' name. So therefore, Your Lordship, now the office is handled by Anu Bharadwaj. Now she's the panel counsel, Your Lordship. Therefore, all this confusion. My sincere apologies,
Request
Your Lordship.
to also appears for the petitioners in these appeals, in these petitions. Seeks a short adjournment. At her request, re-notify. Please give it in September.
Thirtieth 9.
30.
39, madam. 17 Arjun. 15 to 20 Arjun, 21. Virupakshaya. 21.
Hearing for the appellants. It's the appellants are challenging notes, the order passed by the single judge notes, whereby the writ petition notes, which was filed by the petitioner's appellants note, challenging the endorsements notes, which was issued by the special land acquisition officer, was the writ petition filed by the appellants notes came to be dismissed notes. The impugned order, if your lordship kindly peruse this note, is at page 15 note.
What is the difference between 28A and 28.3?
Notes, 28A notes,
Land acquisition.
may I read notes the.
But how many times you can seek enhancement?
They have
That's,
accepted enhancement, thereafter they have filed.
No, we just want to know, once enhancement, can there be a further enhancement?
Malots, I have not sought for enhancement of the compensation, Malots. Rather, Malots, your lordship, may I read, Malots, the provision, Malots. 28A3, Malots.
Which provision?
Malots, your lordship, 28A2, Malots. Section 28A, Malots, redetermination of the amount of compensation on the basis of the award of the court. Malots, may I read, Malots, 28A2, Malots. The may I read, Malots, subclause 2. Malots. The collector shall, on receipt of an application under subsection 1, conduct an inquiry after giving notice to all the persons interested and giving them a reasonable opportunity of being heard, and make an award determining the amount of compensation payable to the applicants. Malots, previously our applications, Malot, which are filed, Malots, under section 28, Malots. An award was passed by the deputy commissioner, Malots, under section 28A2, Malots. Subsequently, Malots, we have filed petitions, Malots, under section 28A3, Malots. May I read, Malots, 28A3, Malots. Any person who has not accepted the award under subsection 2 may, by written application to the collector, require that the matter be referred by the collector for the determination of the court, and the provisions of section 18 to 28 shall apply as far as may be applied to such reference as they apply to a reference under section 18.
Did you approach the court for enhancement reference?
Malots, we filed the application. That application has been rejected, Malots, by the impugned endorsement.
No, you did not. That's the only one time, first time
Please,
enhancement.
Manoj. Please, Manoj. That is the first time enhancement, Manoj. Manoj,
You say,
Your lordship.
Endorsement says
Manoj, the
22, they have accepted and received a check.
that must be the compensation,
Compensation.
initial compensation.
Yes, ma'am.
But where is the enhancement?
Manoj, our applications, Manoj, are at page 28, Manoj. 82, I'm sorry, Manoj. Annexure C1, Manoj. This is under section 28A3, Manoj. Your lordship kindly peruses, Manoj, the application, Manoj. At page 84, Manoj.
But how would you answer para 3? Para 3.
Manoj, learned AG, may I read, Manoj, learned AG appearing for the response points out that the petitioner having accepted the enhanced compensation under 28A of 1894 Act in their favor only, and therefore the question of traveling to subsection 3 of 28A would not illogically arise. He also submits that the petitioner having accepted the enhanced compensation are stopped from turning around and now saying anything to the contrary in light of decision of the Honorable Supreme Court. My lord, section 28A3, my lords, my respectful submission, my lord, provides, my lords, an opportunity to the landowner, my lord. If he is not accepted, my lords, the compensation, my lords, which is determined under section 28A2, my lords, they may, my lords, by filing an application. In this case also, may I read, my lords, 28A3, my lord.
See, 28.1.
Please.
Read it in a seriatim.
Please.
In an award under this part, the court allows the applicant pay any amount of compensation in excess of the amount awarded by the collector under 11. The persons interested in all the other land covered by the same notification under 4, subsection 1, and who are aggrieved by the award of the collector may, notwithstanding that they had not made an application to the collector under section 18, by return application to the collector within 3 months from the date of award of the court, require that amount of compensation payable to them may be redetermined on the basis of the amount compensation awarded by the court.
Please,
So you did not approach the court, but the court has in some other case has
Please.
given a larger compensation.
please, my lords.
Then he can move to the collector for that compensation awarded by the.
Please. In the-
Provided that in computing the period variable. So is it such a case?
Such a case, my lord.
Like
Please, my
you
lords.
did, you did
You
not
did,
move
we
it
did not, my lords, file an application under section 18
for court,
for, my lords, enhancement of
for
compensation.
the announcement.
Please. The other landowners, my lords, in the very same
They
notification.
went.
My lords, in an LAC, my lords, the reference court, my lord. The reference court had awarded a compensation, my lords, in respect of other landowners. my lord.
Got it. Mono, what do you say?
Lord, when once they have announcement was taken by them without,
They said
without
they have-
protesting,
No,
without
have-
protesting, they have accepted it, my lord.
There is a compensation awarded by the collector.
Yes, my lord.
There is which they have taken.
Yes, my lord.
By the
Without
collector
protest,
you have taken.
Now, my lords,
they have accepted it.
please, my lord.
Initial compensation
ma'am.
taken
Please, my lord.
without seeking enhancement.
No, my lords.
Now enhancement has been made by the court on a reference sought by the other landowners. That amount gone up. He goes to collector. He goes
Please,
to
ma'am.
collector. Based on that award, say that compensation be given to him, which it appears to be rejected.
My lords, that compensation is awarded, my lords, under subsection 2.
That has been
That
awarded.
has been awarded.
Oh,
My lord, subsection 3 provides, my lord, if I may read, my lords, the next project, subsection 2, my lord. The collector shall on receipt of an application under subsection 1, conduct an inquiry after giving notice to all the persons interested and giving them a reasonable opportunity of being heard and make an award determining the amount of compensation payable to the applicants. This order was passed, my lords, in the year 2022, my lords. We did, my lords, the compensation which is awarded, my lords, under subsection 2, my lords, was not acceptable by the petitioners, appellants. As such, my lord, we made an application, my lords, under subsection 3. My lord, any person who has not accepted the award under subsection 2 may by written application to the collector require that the matter be referred by the collector for the determination of the court, and the provisions of section 18 to 28 shall so far as may be applied to such reference as they applied to a reference under section 18.
so what you say is, though you got the benefit under 28(2),
Please,
you are seeking further enhancement under 3.
please, my lord. But why, please, my lord. My lords, the reason, my lords, we sought for, my lords, enhancement under subsection 3, my lord. We did not accept, my lords, the award which was passed by the land acquisition officer, my lord. Because, my lord, the award,
No, under 2 you did not accept.
that is not acceptable by the appellants, my lord. Subsequent, my lords, to
Now
file,
tell us,
please.
is there any further enhancement?
My lords,
Is there any further enhancement of the?
my lords, those appeals are pending, my lords, before this honorable court, challenging, my lords,
So then how will 3 come into picture?
my lords, 3, my respectful submission, my lords, in the award which was passed, my lords, under subsection 2. My lords, apart from the land which is owned by the appellants, my lord, there are trees, my lords, which were also, my lords, acquired by the special land acquisition officer. In the award which was passed under subsection 2, my lord, in respect of the trees, my lords, there is no compensation awarded, my lords. As such, my lord, in our written application which was filed under subsection 3, my lord, we have sought,
Here is this 2012 3 assessment, just take out this.
my lords, that judgment, my
2012,
lords,
do you have?
please, my lords. In
So-
fact, that is a judgment, my lords, in respect to land acquisition proceedings. It is not under, my lords, section 28, my lords, my respectful submission.
See that?
Para 24, my lord. Para 24, my lords.
This is not under 28.
My lords, it is not, my lords, if your lordship kindly peruse para 24, my lord. That is in the judgment, my lords, may I read, my lords, therefore, in the judgment which the honorable single judge has relied. Therefore, the law on the issue can be summarized to state that in the event that the person interested has not filed objections in response to a notice issued under subsection 5A and has not challenged the acquisition proceedings, the quashing of the declaration issued under section 6 is in some other case would not inure to the benefit of such person. That was a case, my lord, in respect of the land acquisition. Without filing objections, my lord, the appellant had sought to challenge, my lords, the acquisition proceedings. The honorable single judge, my lords, the honorable Supreme Court, my lords, has held, my lord, that such a person who has not objected, my lords, to the acquisition proceedings cannot move the court, my lords, challenging the very acquisition proceedings. That was the judgment, my lords, of the honorable Supreme Court, my lords, which has been relied by the.
If a person has not challenged the acquisition proceedings.
Please, my lord, para 24, my lord, has not challenged the acquisition proceeding, the quashing of the declaration issued under section 6 in some other case would not inure any benefit to such person. More so where the possession of the land has already been taken.
Okay. That's in the context of the
Land,
notification.
please, my lord, in fact, my lords, on section 28A, my lords, itself, the honorable Supreme Court, my lord.
Show us.
My lords. But the first judgment, my lord, reported in 2010, 10 SEC 650, my lord. Para 1, my lords, may I read, my lords, the issue before the honorable court, my lord. The only question which arises for consideration in this appeal filed against the judgment of the division bench of the Andhra Pradesh High Court is whether the application filed by the appellant under section 28A3 of the Land Acquisition Act for making a reference to the court was maintainable, and the High Court committed an error by quashing the proceedings in OP pending in the court of Senior Civil Judge Peddapalli. Let's the facts of the case are narrated. Let's para 5 minutes is relevant. May I read minutes para.
Where is the finding?
Let's finding, if your lordship kindly peruse para 15, my lord. At page 5, my lords, bottom of the page. If subsection 3 of section 28A is interpreted keeping in view the object sought to be achieved by enacting the provision for removing inequality in the matter of payment of compensation, it must be held that a person who is not satisfied with an award.
Are you reading?
My lords, I'm sorry, para 15, my lords, bottom of page 5, my lords.
Bottom of page.
Page number 5, my lords, I have numbered, my lords. Page. I'm sorry, my lords, page number 5. Let's if subsection 3 of section 28A is interpreted keeping in view the object sought to be achieved by enacting the provision for removing inequality in the matter of payment of compensation, it must be held that a person who is not satisfied with an award made under section 28A2 can make an application to the collector under section 28A3 for making a reference to the court as defined in section 3D of the Act. And this right cannot be frustrated merely because as a result of redetermination made under section 28A2 read with section 28A1, the applicant becomes entitled to receive compensation on par with other landowners. There is nothing in the plain language of section 28A3 from which it can be inferred that a person who has not accepted the award made under section 28A2 is precluded from making an application to the collector with a request to refer the matter to the court. Of course, the court to which the reference is made.
Have you received the compensation under 28A2?
Subsequent to filing my protest petition, they have released the compensation.
Under 28.2?
Please,
A2.
please.
You received it?
Please, Manoj.
Then how can you say that you have not?
Even if the judgment of the Honorable Supreme Court says if I have not accepted the award.
Right. Then you will say that you have not received it, they will deposit in a civil court. But once you have received it, will that mean that you have not accepted it?
It was received subsequently, after filing the protest petition.
Where?
Under section 28A3, which was filed, before the Special Land Acquisition Officer. It was filed, my lords, in the month of February 2022, my lords.
No, is there any judgment which says that having received also you can challenge it?
Please, my lords, para 15, my lords.
Huh?
My lords, may I read, my lords, from top, my lords? My lords, may I read it again, my lords, from para 15, my lord? If subsection 3 of section 28A is interpreted keeping in view the object sought to be achieved by enacting the provision of removing inequality in the matter of payment of compensation, it must be held that a person who is not satisfied with an award under section 28A2 can make an application to the collector under 28A3 for making a reference to the court as defined in section 3D of the Act, and his right cannot be frustrated merely because as a result of redetermination made under section 28A2 read with section 28A1, the applicant becomes entitled to receive compensation on par with the landlord, other landowners. There is nothing in the plain language of section 28A3 from which it can be inferred that a person who has not accepted the award made under section 28A2 is precluded from making an application to the collector with the request to refer the matter to the court.
Is it a case that you have not accepted the award?
My lords, we have not accepted the.
How did you get this money?
My lords, it was.
The 28A2.
Please.
How did you get this money?
My lords, it was, my lords, through check, through RTGS, my lords, it was.
We want to know,
Lords,
RTGS
it
or
was-
check?
It was, my lords, through, it was sent, my lords, to the bank account. my lords. Please.
Which
By
you
way of check,
deposited?
Mel. By way of check, they have received.
Which you deposited?
My lords, we have received, my lords, there is no dispute, my lord, we have received the amount.
So what follows?
My lords, as per the award, my lords, which is,
Did you receive this check?
my lords, it was received on 19/3/2022. my lords.
Where is the first communication thereafter?
My lords, my objection, my lords, is in the month of February 2022.
And this you received? What is the, let's see your objections.
My lords, please. My lord, if your lordship kindly peruse page 82, my lords, annexure C1. Lord, at para 80, para 5, my lords, page 84, my lord. My objections, if your lordship, may I read, my lords, para 5 minutes.
When did you give this?
My lords, on the first page, my lord, it is dated 16/2/2022, my lord. Page 82, my lords. The seal, my lords, of the Office of the Third Respondent Authority.
So after this,
Please. My lord, para 5, may I read, my lords, at page 84, my lord. It is, may I read, my lords, para 5, my lord. It is further submitted that in pursuance of the judgment and award in LAC number 30 of 2007 dated so-and-so and LAC number so-and-so, the claimant herein filed application under section 28A of the Land Acquisition Act seeking to redetermine the amount of compensation in respect of the acquired land and trees. The Special Land Acquisition Officer was pleased to recommend for approval of the redetermination of amount of compensation payable in favor of the claimant. It is submitted that the Deputy Commissioner was pleased to pass an award on 13/1/2022 in pursuance of the recommendation by redetermining the compensation in favor of the claimant herein. It is submitted that the official memorandum dated 13/1/2022 by official memorandum dated 13/1/2020, the application filed by the claimant under section 28A of the land has been allowed and compensation has been awarded in terms of the judgment and award. It is submitted that while awarding compensation, the statutory benefits provided under section 23(2) of the Land Acquisition Act, which provides for awarding an addition, in addition to the market value of the land, the court shall in every case award a sum of 30% on such market value in consideration of the compulsory nature of the acquisition is to be awarded. However, while passing the award, the benefit of 30% solution as provided under section 23(2) of the Act has not been awarded. Further, in spite of the fact that several trees were standing at the time of acquisition, the market value of the acquired trees and borewell have not been determined and no award is passed in respect of the trees and borewell. Only in respect of the acquired land, the compensation is enhanced by award dated 13/1/2022. The compensation awarded in favor of the claimant in respect of the acquired land is very meager. In fact, in several other cases pertaining to enhancement of compensation in respect of the acquired land and trees, higher compensation is awarded. As such, it is just unnecessary to refer the incident matter for redetermination to the court. In the facts and circumstances narrated above, the appellant claimant humbly prays that this honorable authority may be pleased to refer the matter to the jurisdictional court for enhancement of the compensation payable, including 30% solatium in respect of the land, bearing survey number so-and-so, along with trees and borewell in the interest of. My lord, in the award, my lord,
Where do you say this is 28-3?
my lord, sir, in the first page, my lord, page 82, my lord. Memorandum of application under section 28A3.
And this happened on
16th of February 2022, my lord.
and 19th, you have received the amount.
My lord, on 19th March, my lord, we have received the amount.
Thereafter,
My lord, thereafter, the impugned endorsement, my lord, at page 112, my lord, is issued. My lord, 113, my lord, is the translated copy. My lord. My lord,
how do we get this enhanced compensation is under 28A2?
my lord, the first compensation which is paid.
That's
my lord.
right.
My lord,
First is collector, whatever has
Yes.
been determined given. The enhanced is.
my lord, the order, my lord, the subsequent order, my lord, which is passed by the SLAO, my lord, is at page, my lord, 40, my lord, annexure B1. The translated copy, my lord, is at page 43, my lord. This is the award, my lord, under section 28A2, my lord.
How much you had got initially?
My lord, initially it was, my lord, 15,000 rupees, my lord. My lord, there are six,
Total.
please, my lord, in respect of the entire land. There are 7 petitioners, my lord. Similar endorsement, my lords, have been issued, my lords, in respect of all the appellants. My lords, in respect of the first appellant, if your lordship kindly peruse, page 43, my lords, is the award. Page 45, my lords, is the compensation. Which
Tell us one thing, but you did not seek any enhancement after that collector had given. This you got the benefit because someone else had got it.
Please.
But would you be still entitled to the benefit under 28A3?
My lords, if your lordship, my lords, the third judgment which the Honorable Supreme Court, my lords, even if I protest, my lords, or do not protest, my lord, the Honorable Supreme Court has held, my lords, I can very well, my lords, maintain an application under section 28, even with or without protest.
28-3.
28, my lords, please, my lord. My lords, the last judgment, if your lordship kindly peruse, page 17, my lord.
Yes, what do you say?
But when once they are not protested and they have taken compensation, it has been finalized. They are not entitled for any enhancement thereafter. As per my. Earlier determination was made, thereafter entire revised and award has been passed.
Have you expressed your protest after 16th of
My lord, since
March when you received that?
my lord,
amount?
since our application, my lords, which was filed in the month of February, is pending consideration. Subsequently, my lords, we have not filed any other protest petition.
So that means, that's what we want to say.
Please.
You have received that amount.
My lords, one other
It's
aspect.
as good as accepting that amount.
Lords, one other aspect, my lord, in the award which was passed, my lords, under section 28A2, my lords, there was no, my lords, compensation which was determined in respect of the trees. And also 30%, so
You
as
are
such,
right.
my lord,
Even we were considering that only.
please.
See, it can happen that the award which has come in the same notification, land of the same notification, there may not be any trees. There may not be any trees.
However, my lords, that is why, my lords, we had sought for referring the matter to the jurisdictional civil court for reconsideration, my lords, to conduct an inquiry, my lords, at least in respect of the. Not in the third judgment, if you
Show us.
reported in 2002, Manoj, page 17, if your lordship kindly produced. 2002, 7 SCC 273, Manoj. May I request your lordships, Manoj, to kindly have Manoj para 11, Manoj, at page 26, Manoj. Coming to the second question for reference, the receipt of compensation with or without protest pursuant to the award of the land acquisition collector is of no consequence for the purpose of making a fresh application under section 28A. If a person has not filed an application under 18 of the Act to make a reference, then irrespective of the fact whether he has received the compensation awarded by the collector with or without protest, he would be a person aggrieved within the meaning of section 28A and would be entitled to make an application when some other landowner's application for reference is answered by the reference court. It is apparent on the plain language of the provisions of section 28A of the Act. Otherwise, it would amount to adding one more condition not contemplated or stipulated by the legislature itself to deny the benefit of substantial right conferred upon the owner. This was a case, my lord, where the Honorable Supreme Court, my lord, has held, my lords, whether a applicant who has not filed an application under section 18 previously, my lord, on par with the other landowners who had made an application, my lord, seeking reference of the court, whether they can maintain an application for under section 28, my lords, was the issue.
28A2.
A2, 28, my lords, please, my lords. Under 28A, my lords.
28A, which includes 2 also.
2, please, my lords.
And may include 28.3 also.
3 also.
No, we were only thinking this. Suppose you went under 28.2.
Please.
Or you went, you did not go under 18.
Please.
That's what. But there is an enhancement in respect of certain landowner. Then you can go under 28.2.
Please.
But you did not go under 28.2.
That's, we filed my lord's application. That is the award, my lords, by the land acquisition officer. We were not satisfied, my lords, with the award passed under 28.2. A2. As such,
You were the applicant for 28.2.
28A2, we were the applicants. The award which was passed by this special land acquisition officer, my lord, it is, my lord, granting very meager compensation in respect of the land. And there is no compensation, my lords, granted in respect of the acquired trees.
But did you file an application under seeking reference under 18?
We did not file, my lords.
You did not.
Please.
And 28A2, you went because of the award in the
Please,
other case.
in the other case.
You got the benefit.
Please. The Honorable Supreme, in the last case, my lord, that was the issue, my lords, for consideration, my lords, whether the landowner can maintain an application under 28.2 if he has not filed an application under section 18 previously. That was the reference, my lords, in the judgment, last judgment, my lords.
This 11
Please.
is in the context of 28A2. Read it. It doesn't say so.
My lords, with
Coming
regard
to the
to
second
protest, my lord.
Just read
Please.
it.
If a person, coming to the second question for reference, the receipt of compensation with or without protest pursuant to the award of the land acquisition is of no consequence for the purpose of making a fresh application under section 28A. If a person has not filed an application under 18 of the Act to make a reference, then irrespective of the fact whether he has received the compensation awarded by the collector with or without protest, he would be a aggrieved person aggrieved within the meaning of section 28A and would be entitled to make an application when some other landowner's application.
That's right.
Please,
Then some other landowners have got the benefit.
Please, ma'am.
So it's like this. You did not, as a person, you did not seek reference. He sought reference. In his reference, the amount was increased.
Please.
Then you will not be precluded because he has got, this is equality, you know. For the same land, one is getting a higher compensation, you are not getting. The court says yes.
Please.
Irrespective protest is there or not, but we are not in that scenario. We are in the scenario of 28A3.
Please.
28A3, that's what we are putting it to you, is if someone has got 28A3 doesn't say that some other person has got a higher award. It doesn't say so. It says if a person 28A2
Please. if he's not accepted the award.
He has not accepted the award, then he can go under 2883 saying that, I am entitled to more.
Please.
Not this, I am entitled to more. Though you have given this
That's-
because
That,
this gentleman has received more and I am entitled to, but I am still saying more. Now, we just want to know, when you did not seek reference under 18, you did not seek.
Yes.
Because you got the benefit of 28.2 because some other had got the benefit. Now, can you file 28A3? That's one. And this receipt of the amount will amount to accepting the award under 28A2. That's the issue. The para you have read is 18 to 28A2.
That's my respectful submission. It considers 28A, Manoj.
It says 28A.
Please.
It has to be read in context. That context was a person did not seek reference, but another person got the benefit of an enhanced
But even-
compensation,
Please.
28A2.
Manoj, even in my case, Manoj, my respectful submission, Manoj, when the SLA was passed an award, Manoj, in respect of the land, he could not have, Manoj, excluded, Manoj, he could not have, Manoj, passed the award without granting, Manoj, awarding compensation in
Okay,
respect of this case.
let's test this argument.
Please,
You did not file 18,
please.
you have accepted. But someone got under 28A2, someone got a higher compensation under 18.
Please.
That's right. Then you said he got more, I should also get it.
Please.
You are right in going, they have gone. Can you, under that scenario, would challenge 28A2 award saying that whatever I got is less? Once you have not challenged the earlier compensation, how can you challenge? In effect, what you are challenging is 28A2.
Please, Manoj. 28A2, Manoj, the award which is passed, Manoj, by the SLA, Manoj, is, Manoj, without considering, Manoj, the fact that there were also trees, Manoj, in respect of the acquired land.
That the only judgment is one Justice Singhvi's judgment.
Please.
But what Justice Singhvi says is, if he has not accepted 28A2, now let's see that judgment once again.
Please.
You were reading
Manoj, sir. Manoj, sir, the,
15.
please.
Read
So
it.
the facts of the case, Manoj, the para 5 and 6, Manoj, may I read, Manoj?
Let's read it.
Para
5
5.
and 6.
Para 5, Manoj, may I read? The appellant who had not invoked section 18 of the Act filed an application under section 28A1 for payment of enhanced compensation on par with other landowners, at whose instance reference was made by the collector. By an order dated 31/12/1990, the land acquisition officer held that the appellant is entitled to receive compensation on a par with other landowners. On the same day, the appellant filed an application under section 28A3 of the Act for making a reference to the court for fixing the fair market value of the acquired land by asserting that he was accepting the amount of compensation under protest. The land acquisition officer referred the matter to the collector Karimnagar, who accorded permission for making a reference to the court. Thereupon, the land acquisition officer sent communication dated 2/6/2000 to the reference court for fixing the fair market value of the appellant's land. Respondent number 1 challenged the aforesaid communication in writ petition number so-and-so, which was dismissed by the learned single judge, with an observation that the civil court is already seized of the matter in so-and-so, and the petitioner can agitate all the points, including the one relating to maintainability of reference made under section 28A3. The division bench allowed the appeal preferred by respondent number 1, set aside the order of learned single judge, and held that a person who gets benefit of higher compensation under section 28A1 cannot file an application under section 28A3. My lord, 7 and 8, my lords, are the submissions, my lord, which are considered. Subsequently, my lords, decisions, my lord, para 12, 13 and 14, my lords, are the decisions which are considered.
That's 15C.
Para 15, my lords. If subsection 3 of section 28A is interpreted keeping in view the object sought to be achieved by enacting the provision for removing inequality in the matter of payment of compensation, it must be held that a person who is not satisfied with an award made under section 28A2 can make an application to the collector under section 28A3 for making a reference to the court as defined in section 3(8) of the Act. And this right cannot be frustrated merely because as a result of redetermination made under section 28A2, read with section 28A1, the applicant becomes entitled to receive compensation on par with other landowners. There is nothing in the plain language of section 28A3 from which it can be inferred that a person who has not accepted the award made under section 28A2 is precluded from making an application to the collector with the request to refer the matter to the court. Of course, the court to which reference is made under section 28A3 will have to bear in mind that a person who has not sought reference under section 18 cannot get compensation higher than the one payable to those who had sought reference under that section.
That's what we are saying. So, in the absence of 18, you can only get what?
What the other landowners have got. My lord.
All.
That, my lords, my respectful submission, my lord, in respect of the trees which were acquired, my lords, the section 28A3, my lords, may I read it, my lords? It says, my lord, the person who has not accepted the award, then the SLAO, my lords, a written application to the collector required that the matter be referred. The collector, my lords, the duty of the collector under section 28A3, my lord, where may I read, my lord, section 28. Any person who has not accepted the award under subsection 2 may by written application to the collector require that the matter be referred by the collector for the determination of the court, and the provisions of section 18 to 28 shall so far as may be applied to such reference as they applied to a reference under section 18.
Where is this judgment followed? 2010. The one which you have read.
Please, madam.
Has it been followed later?
My lord, I'll have 2 minutes verify now. Sir.
You check up.
Please.
We'll take it up after lunch. Check up.
Please.
We'll see. Okay. See, now also, once you have accepted the award under, of the payment under the.
That's one submission, my lords. Under section 28A3, my lords, the duty, my lords, the duty is cast, my lords, upon the, my lords, if I am a person aggrieved, my lords, I have to file an application. Then, my lords, it says, return application to the collector, require that the matter be referred by the collector. It only says, my lords, that in application which is filed, my lords, by the land loser, my lord, the duty of the special land acquisition officer, my lords, is only, my lords, if he is not, if a land loser, my lords, is not satisfied with the award, then the duty of the land acquisition officer, my lords, is to refer
like a reference under 18.
My lords, he has to only refer, my lords, the application to the jurisdiction of civil court. If at all, my lords, I am not entitled and there is no other person, land loser, who has been awarded the compensation higher than the compensation which is paid to the appellant,
can be denied. Then,
my lords, then the jurisdiction civil court, my lords, will come to the conclusion that I am not entitled. However, my lords, the subsection 3 only says, my lord, the duty, my lords, of the collector.
You are only seeking a reference.
My lords, he only has to refer, my lords, the matter.
Right.
However, my lords, the impugned endorsement is now issued, my lord. He says, my lords, that I cannot refer the matter to the civil court.
No, that's right. See, reference is not mechanical. Everything which has come, I'll refer it.
Let's see.
He will apply his mind. Surely, once he says, yes, it requires consideration, he may. But he
says, my lord, that having received the compensation under section 28(2), you cannot maintain this application. That is the only, my lords, that is one line finding, my lords, which is given by the SLAO.
What you are arguing is, it is not for him to say.
Please,
it is for the
civil court, my lords, whether I am entitled to the compensation. Once I have received the compensation and you are entitled for the, under section 28(3) is a matter to be decided by the civil court, my lord. And, my lords, there are other issues also, my lord, whether the enhanced compensation, whether I am entitled to enhanced compensation or not, my lords, is one of the issue.
See, there is one observation in that judgment of Supreme Court, that one at that Justice Inglis, para 15, if you see page 6.
Please.
Fourth line, fifth line, there is nothing in the plain language of 28(3) from which it can be inferred that a person who has not accepted the award made under 28(2) is precluded from making an application to the collector with the request to refer the matter to the court.
Please.
Now read the next sentence.
Of course, the court to which reference is made under section 20. Please.
We'll have to bear in mind that a person who has not reference under 18 cannot get compensation.
Please, my lord.
It like your case also, you have.
I cannot, my lords,
But that will be determined by the.
by the
court.
civil court, my lord. I cannot, my lords, I will not seek any enhanced compensation which is granted to the other landowners, my lord. But that issue has to be determined, my lords, by the civil court.
So what it is there is an issue, whether you are
Please, my lord.
entitled, it is for the civil court, you will
Please,
not,
my
put- you will not put a spoke here.
Please, my lord. My lords, in addition to the enhanced compensation, my respectful submission, my lord, that in respect of the trees, there is no compensation awarded by the SLAO.
In
That
those
also is the issue.
In those cases, trees were not looked into.
Lords, there are other cases, my lord, in the similarly placed, in the same village, my lord, where compensation in respect of the trees has been awarded. If the matter goes before the civil court, my lord, I can,
But was it a higher compensation?
my lords, it was a higher compensation. There is no compensation awarded at all, my lords, by the SLAO now, my lords.
Under 28(2), the benefit of 28(2) which you had sought, let's hypothetically say 100 rupees.
Please.
Was there any award in respect of other landowners where the award was 150 rupees?
Please, my lords, in respect of the trees.
Or in respect of the
Trees also.
Prayer before the single judge was, my lord, issue writ of certiorari seeking a quashing of an endorsement.
And to refer the matter, my lords, sir.
And thereof, you just check 28(3), this judgment has
He is
been
not,
followed.
he is not
I will-
questioned that award before this, in the writ petition. He is
But
not.
tell us one thing,
Yes,
with respect to him, he got the benefit of under 28(a)(2),
yes,
where there were no trees. 100 rupees.
I'll find out from the records. man.
No, but what? No, very well. See. He may succeed, he may not succeed. Suppose he says, look here, I got the benefit of 28(a)(2) under these circumstances. But mine is additionally, I should get the benefit of those trees which were standing there on the land.
The award was accepted by him, my lord. Award was not questioned. In this writ petition, the award was not questioned.
He will not
Only
question.
endorsement was issued, was questioned by him, saying that I have received a compensation. As such, we are not making a reference, was questioned before him, before the
He will not
single
get
judgment.
the award. He got the benefit. He's saying, I am entitled to a higher compensation.
Then he has to question the award, my lord.
Why?
He has to question the award, saying that the determination was not made in respect of trees. That has to be established before the land acquisition officer. If he is not considered, then only he has a case. He is not, the award was not questioned by him.
That's 28(a)(3) says.
Award was not questioned by him.
Any person who has not accepted the award.
Ah.
28(a)(3) says, my lord.
They not accepted the award. It's not a questioning the award. It's like this. Very well. He will not question the award. Award gives 100 rupees to him.
Yes.
He said, I am not entitled to 100, I am entitled to much more, 150. The 150 request has been rejected. He will fall back upon 100 rupees, saying that now you give me 100 rupees. There is no need for him to. He is saying, I am not accepted the award. I am not challenging the award. I am not accepted. I am not satisfied with this 100. I am entitled to 150. And what is wrong? If the person says, okay, give me 100 under protest, I want 150, please determine whether I am entitled to 150 or not. He says, very well, the court will accept or not. The court will say, no, 150 you are not entitled. Then he says, I am satisfied with what I got. Getting the point? Just look under these.
Lords, I'll-
We'll have it after lunch. We'll come back after lunch.
Yes, my lord.
Yes.
21, cell number 21.
Please.
Did you get any judgment?
My lords, there is no judgment of the Honorable Supreme Court, my lords, subsequent to the judgment, my lords, of the year 2010, rendered by His Lordship Justice Singhvi. My lords, there is no judgment, my lords, of the Honorable Supreme Court. There is one judgment of this Honorable Court, my lords. However, the Honorable Single Judge, my lords, has followed the judgment. It was an appeal, my lords. Lords, this was a case, my lords, it was an appeal, my lords, challenging the award passed by the reference court, my lords, on an application under section 28(3). That appeal was filed, my lords, by the, but the Honorable Court has held, my lords, that the application would be maintainable, my lords, under section 28(3). The Lordship may kindly, my lords, para 8, my lord. The Honorable Supreme Court judgment is followed, my lord.
You said.
Miller, in this act itself is clear, Miller. When once 28(3, Miller. Any person, I read, Miller. Any person who has not accepted the award under subsection 2 may, by written application to the collector, require the matter be referred to the collector for determination of the court, and provisions of the section 18 to 28 shall so far as may be applied to the reference under section 8. If he is accepted, here it says not accepted. They have accepted, Miller. They have accepted the award.
It is the protest.
My lords, if your Lordship kindly peruse my application, my lord, which was filed, my lords, under section 28(3), my lords, before the special land acquisition officer, my lord. Page 82, my lord. My lord, para 8, if your Lordship kindly peruse. My lord, apart from the fact that, my lord, in para 7, my lords, I have stated that the compensation in respect of the trees was not awarded, my lords, by the special land acquisition officer. Para 8, my lords, I have stated the compensation awarded in favor of the claimant in respect of the acquired land is very meager. In fact, in several other cases pertaining to enhancement of compensation in respect of the acquired.
The date of this.
My lords, it was filed, my lords, on 16th of February 2022, my lords.
15th March. The signature only goes on this, keeping in view the conformity in provisions of 28(8).
Please.
You have given me check, I am not accepting, because I have other claims.
My lords, with regard to.
And thereafter, there is nothing under protest.
My lords, my application was pending consideration. By the impugned.
62, which happened much before March.
Please, my lords, by the impugned, my lords, endorsement dated 12th of October 2022, my lord. That is, my lords, at page 112, my lords, annexure D1. My lords, the only reason, my lord, if your Lordship kindly peruse, my lord, the endorsement. It says, my lord, in view of the above, the applicant herein having filed an application under section 28A of the Act, after holding inquiry, an award is already passed, and the amount was paid through check after obtaining approval from the Deputy Commissioner. As such, the instant successive application cannot be considered. My lord, before,
Also said that if you have accepted the
my lord, he says, my lord, that after an inquiry and award is passed, my lord, and the amount is already released in favor of the claimant. As such, successive application cannot be considered. My lord, my lords, in the application protest petition which was filed by the appellants, we, my lords, only made a request, my lord, that the matter be referred to the civil court. However, the special land acquisition officer holds, my lord.
actually, day,
Please.
is actually in conformity with 28. For the reason simple, that you have not accepted the award.
Please.
Given, and by the time this year the benefit of 28 was given to you.
Please.
Was given to you, but no check was given.
Please.
You made an application under
Under
28A, seeking reference.
Please.
By the time they gave you this check,
Please.
which you encashed.
Please.
If that encashment is there, what would be construed? Will it be construed as to me that you have accepted the benefit under 28A2?
Yes. My lords, that is, my lords, the Honorable Supreme Court, my lords, in the third judgment, my lords, which I referred to your lordships, my lord, whether under protest or not, my lord, the claimant, my lord, would be entitled to file, my lords, an application under section 28A. My lord, in this case, what has happened, my lord? My lords, apart from the fact that the appellants are seeking enhancement of compensation, my lords, the compensation which is required to be paid in respect of the trees, that is not at all, my lords, awarded. Please.
See, that's a point. We agree there. So now let's examine what is the remedy for you. You did not seek your reference under 18.
Please.
Because some other landowners got it, you saw benefit under 28A2. And mind it, when you have not sought the reference under 18, whatever benefits the other landowners have got it under 28A2, you would get that much.
My lords, nothing more, my lords, nothing more. If my lords, if an appeal is preferred, my lords, against the judgment wherein, my lords, compensation is awarded, higher compensation is awarded in respect of the other landowners, I would then be entitled, my lords, to that higher compensation also, my lord.
Say, you have given me this check, I am not accepting this check because I have a higher claim.
Lords, that my respect.
Having said that,
My lords, subsequently, my lords, because, my lords, the protest petition was, my lords, filed in the month of February, my lord.
it's transpired later.
Please.
You said you have given me check, why should I encash it? Why should I encash it? I have a higher claim. If the intent of 28A3 is you have not accepted, then you will have a remedy under 28A3. When is the remedy available?
My lords, the Honorable Supreme Court, my lords, in the decision, my lords, of the year 2002, my lord.
We have seen, read it,
My lords, please.
read it.
My lord, page 26, my lord, para 11, my lords. Coming to the second question for reference, the receipt of compensation with or without protest pursuant to the award of land acquisition collector is of no consequence for the purpose of making a fresh application under section 28A. If a person has not filed an application under section 18 of the Act to make a reference, then irrespective of the fact whether he has received the compensation awarded by the collector with or without protest, he would be a person aggrieved within the meaning of section 28A and would be entitled to make an application when some other landowner's application. Please.
This is different.
My lords, Yogesh.
So you
Not
get,
applicable. Please.
this 11 is in the context of 28.2. And this is your case. You did not raise 18.
Please.
But other landowners got it. You sought the benefit
Please.
thereof. So this para 11 is identical to this situation which you are in.
Please.
But we are not concerned with this situation. We are concerned with a different situation where over and above 28A2, you are seeking benefit under 28A3.
My lords, that the reason, my lords, please.
See, the intent of the Supreme Court in this is 18 you have not filed, like you.
Please.
But other landowners got a higher compensation. The equality clause will come in.
My lords, if my respectful submission, my lords, if the other landowners, my lord, prefer an appeal and if higher compensation is awarded, my lords, the appellant, my lords, would also be entitled to that higher compensation. That, my lords, would be adjudicated by the civil court.
Is it your case? Is it your case?
Please.
That there are other landowners.
Please, my lord. My case, please.
Who got
Higher
much
compensation.
higher compensation than yours.
Please, my lord. With respect to the land, as well as the trees, my lord, which were acquired by the respondent authorities.
Let's assume hypothetically,
Please.
by this 28A2 benefit, how much you got?
My lords, the compensation awarded, my lords,
It's 3 lakhs something.
please, my lord. 1 lakh, my lords, in respect of the first appellant. 1 lakh rupees.
Is it by way of the land area?
It is in respect of the land, my lords, only in respect.
How much they have?
My lords, per gunta, my lords, they have quantified, my lords, at rupees 4,000, my lords.
4,000.
Please.
How much the person which is got it?
My lords, it is, my lords, enhanced by 14,000. The other appeals, there are other appeals also, my lord, in respect of the very same purpose. It is, my lords, in respect. My lord, there are several cases, my lord, in respect of the land acquisition matters, my lord. In fact, at para 8, if your lordship kindly peruses, my lord. Lord, in fact, in my protest petition at para 8, my lord, I have not narrated, my lords, the specific case number. However, I have stated, my lords, in respect of the very same acquisition proceedings, there are several other cases which pertaining to, my lords, the seeking enhancement of.
Please, 28 is a lesser compensation.
Please.
There are people who got a
Higher compensation, other than, my lords, the landowners the other landowners, my lords, which the reference court has awarded. Please.
Now tell us, this background, you won't dispute that there are landowners who got it.
I have to seek instructions to that effect.
Then he may be right, and he may be right in relying upon this. See, the intent of 28(2) and 28A3 is that a landowner must not suffer, or he should be treated equally amongst the equals. There are landowners who got a higher compensation. Can a landowner under the same notification be denied a lesser, be given a lesser compensation? The intent is the Supreme Court says no, equality clause will come in. That is so. According to him, what the benefit I have got 28A2 is the benefit which have been given to certain landowners. But there are certain landowners who have got a higher compensation because of ABC factors. Like there are
Yes,
things which are there. Let's assume one fact. They got an 14,000, why he should not get it? Merely because he has accepted the compensation under 28A2 would preclude him from seeking a reference for a higher compensation. That's the issue. How would you answer that?
They have not met that as a ground before single judgment.
As a,
Ground before single judgment.
let's see. Pick the one which, let's see the repetition. Where have you taken this ground?
My lords, my lords, at page, if your lordship kindly peruse page 28, my lord. 28, my lord. My lord, para 13, if your lordship kindly peruse. On 13/1/2022, the second respondent authority passed an order redetermining the compensation payable in favor of the petitioner. However, the compensation determined by the is very meager and not in accordance with the market value of the lands. As such, the petitioners herein filed applications under section 28A3 of the to refer the matter to the jurisdictional court. Rejection of the
So, see, what is 28A3 contemplates? You are not, it is not your case that the others have got a higher compensation. I am similarly placed, I should also get that compensation.
My lord, if your lordship kindly peruse the protest in the protest petition, I have narrated, my lords. At page, if your lordship kindly peruse page 85, my lord. Which was filed, my lords, before the third respondent authority. Para 8, my lords, of page 85, my lord.
We want as a fact,
Please,
where you say 14,000, others have got, you have.
my lords, my lords, in addition,
14,000 is for
please.
fees.
My lords, in addition, my lord, in respect of trees, my lord, there is separate compensation awarded in respect of each tree, my lord. Apart from the compensation awarded in respect of the land.
So, say in your.
My lord, if your lordship kindly peruse, my lord, para, my lords, page 85, my lord, para 7, my lord, my lords, previous page, my lord, 84, page 7. It is submitted while awarding compensation, the statutory benefits provided under section 23, which provides for awarding in addition to the market value of the court shall in every case award a sum of 30% on such market value in consideration of the compulsory nature of acquisition is to be awarded. However, while passing award dated 13/1/2020, the benefit of 30% solatium as provided under section 23(2) of the Act has not been awarded. Further, in spite of the fact that several trees were standing at the time of acquisition, the market value of acquired trees and borewell have not been determined and no award is passed in respect of the trees and borewell. Only in respect of the acquired land, the compensation is enhanced by award dated 13/1/2022. It is submitted that the compensation awarded in favor of the claimant in respect of the acquired land is very meager. In fact, in several other cases, my lord, para 8, my lord. In fact, in several other cases pertaining to enhancement of compensation in respect of the acquired land and trees, higher amount of compensation is awarded. As such, it is just necessary to refer the instant matter for redetermination of the court. My lord, by the award, my lords, passed by the third respondent authority, my lord, there is no compensation at all, my lord, in the entire award, which is awarded in respect of the, awarded in respect of the trees. Award is only in respect of the land.
Anything else? We deserve. Thank you.
Grateful.
In prescribed time, he has to file an application for enhancement, which was also not done by him.
You are here for all?
Yes, ma'am.
Notice was issued, my lord. Notice.
Yes, ma'am.
So you are
1, 2,
here for
3.
all, huh?
Yes, ma'am. 1, 2, 3.
This says this to the consent of the council for the parties. It has been heard. This is a.
Grateful. Oh, blind. Great.
Provided that, my lord, within 3 months, he has to make an application for enhancement. Which was also. Yes. No, ma'am. It's not.
Thank you.
Would like.
We'll consider this also.
Yes, ma'am.
2024. Serial number 24. Count
Maybe.
advocate.
It may be passed out. ma'am. Age one. This is in respect of temple.
Eighty.
You appear for the 5 years submissions.
23/9.
That is there. Possibly you will have to do a memo or something like that. Not in this appeal.
Not in this.
In this. you sure?
No, not there. Contempt.
So must be there. Based on that, it can be listed here, not in this appeal.
Number is given in that contempt petition.
Right?
And the honorable chief justice order that it should be.
To file a memo.
Yes.
You will take it.
Yes, I have that, 1 second.
Contempt shall already be. It's correct, madam. Contempt shall be-
May I pass on this? My lord, first sentence, to be listed with writ appeal number 209 of 2024, first line itself. The date of this was on 12/3/2024.
Contempt date ಕೊಟ್ಟಿದ್ದಾರೆ. Contempt date ಕೊಟ್ಟಿದ್ದಾರೆ.
That is the contempt.
That is 8th of July.
Yes. 8th of July. 8th of July, this order was passed. That when the contempt, allowed me, just.
The contempt petition shall follow the course of writ appeal 209.
Yes, my lord.
The order passed within.
Yes.
So.
Yes.
It wants to list a contempt petition here.
Contempt petition is, my lord, it may have to be because for this reason, my lord, the Justice Arvind Kumar, KV Arvind Kumar has passed the order which is under challenge in this writ appeal. That division bench, because when it was mentioned to the court, that's the reason.
That says not before justice.
It, yeah, yes, it is, it doesn't so. Yes, ma'am. That's the reason.
Okay.
Yes.
So this order is passed
In CCC 307, first line.
that's right. But this is writ appeal.
Yes, against the same order.
But we don't know, maybe you have to. We don't know what is the, see. What has been said is the contempt petition shall follow the course of writ appeal in view of the order passed therein.
Yes.
Does it mean that this would be, that should be listed along with this?
No, there is no specific.
We say nothing. We say nothing.
Yes,
This
because,
has to come here, you call up the order.
yes. I shall file a reply.
No, we want submissions to be made. You are for the respondent.
I am for the respondent. Yes.
You
The,
will file, both of you will file your written submissions. The records you want to rely. Within 4 weeks.
only submission, there is urgency because of this reason. There is a temple. The temple is looked after by these respondents. All of a sudden, there was a suit, appeal, regular second appeal, in all that title of the temple managed by these respondents has been established. Thereafter, they make an application to the Commissioner of Endowments, that comes under section 42 of the Hindu Religious Endowments Act, wherein they said that management should be, temple should be notified. Without looking into the proceedings, Deputy Commissioner passes an order for the notified.
You wanted a date of, list of dates also.
Yes, ma'am. Yes.
Just say this. The council for the publish shall file. Of dates and the synopsis, Along with the judgment, they want to rely 50 weeks. Let's see, give it in
13/9, sir.
Because the temple is closed, my lord. Because of that, and the Tahsildar of that particular taluk, the Deputy Commissioner directed the Tahsildar to open the lock because of the order. Please.
25. 20. Parshuram.
13(9).
File returns.
I may be permitted to withdraw the appeal.
My lords, the previous matter, I'm sorry, my lords, I was on my legs on the other court.
Yes.
Lord, the only grievance the state is facing is that there is a contempt initiative. My lords, contempt 307. Lords, the temple, my lords, was taken over by the state under section 43. And that 43 proceedings were initiated in view of the division bench's direction in the PIL. And the only reasoning given by the learned single judge, my lords, is that the inquiry has not been done properly is the first reasoning. The second reasoning is approach the civil court under section 92. My lords, the learned single judge has not looked into the fact that section 92 application has already been dismissed by the civil court. And my lords, now in view of this contempt proceedings, my lords, I maybe not be precipitated till my lords kindly hear them. Date is not given. Contempt 307 of 24 is, please, my lords, date is not been given.
We are giving it here, finally hearing, are you proceeding? Do you have a date in?
My lord, for this, because these devotees, they can't go to the temple.
We want your submissions to be.
Yes, yes.
We will file our written submissions, my lords. Please.
My lord, on the statement that because the division bench directed, therefore this temple is notified is not correct. On fact, Deputy Commissioner, without going into the minutes of it, has ordered.
A complete inquiry was done. Show cause notice is given. They have filed a reply. The entire extract is available. Nothing has been looked into by the learned single judge with great respect. The only thing is, my lord, that, please, my lord.
This is your appeal.
Please, state appeal. I'm sorry, it's a state appeal, my lords. It's a temple,
There is a direction to open the lock, my lord.
There's a huge mismanagement. Any shorter date, my lords, and not to precipitate, may I request?
My lord, for that I need to file objections because there is a, my lord, my learned friend is coming, getting this contempt. Not
before, my lords. Request till it is decided, my lords.
My lord, a short date is given, I will be able to satisfy this.
Please, great.
Fine, sir.
Please.
But we want your submissions.
Please, we will put it in writing, my lords. Grateful. Obliged, ma'am.
25.
Appear for appellant. I may be permitted to withdraw the appeal, my lord. Memo, my lord.
Date.
You're going to go back.
Yes, my lord.
For review of the memo and the liberation of the prayer made in the memo, either also for that, the appeal is dismissed. Let's see any.
Sir, delay of 7 days, one stay.
The review of the order in the ISF.
26. Radha Krishna Holla.
Petition, my lord. This is a case, my lord, wherein the GTS employee, my lord, was deputed to Army Postal Service in 1997. He came back in 2004 on his request, repatriated to the Revenue Department. While repatriating, my lord, he was working as a Group D. Now he has been posted as GTS, my lord. My submission is that, my lord, because there's some delay is there, my lord, no doubt about it.
My lord, on
The case before the trial.
Tribunal, my case was that, my lord, because there is no order of reversion.
Yes, Mr. Page.
That this honorable,
Page 17.
yes, my lord. To call for records from the respondents and issue directions to consider the applicant's case for appointment to the cadre of MTS from the date of his reversion to civil side or from the date of his juniors were appointed in MTS cadre in the interest of justice and equity. Other day, your lordship wanted to know from my other side.
See that also. We'll ask you very Now come to, we want to know what was the scope of the OA.
My main ground is that, my lord, a person was working as Group D has been reverted to GDS in contravention of Article 311, I mean the 312, I mean,
We'll see that, we will see that. Now, to pass orders, deal with, pass GDS this, wide representation this, seek appointment as MTS.
yes, my lord,
Now, you were working as what when you went to APS?
GDS, my lord.
You were working as GDS?
GDS last day, my lord, I was promoted as Group D. Before sending me,
Before sending you to APS?
whatever, my lord, I continued as such for 7 years. Yes, ma'am. Yes, ma'am.
Now, what was your terms of appointment when you were sent to APS?
My lord, page number 104, my lord.
Yes. Oh, that is his, yes,
Page number
undertaking given
104.
by him. The terms in fact is annexure R1 or annexure 7, R1 you are last making, she herself has produced that 93 page number.
And when were you repatriated from APS?
2004, my lord.
So that's quite long back.
Yes, ma'am.
Voluntary, he requested and it was premature repatriation.
Your request you had come.
Yes, my lord, you are permitted to go, I mean, it is there.
So repatriation
Yes, my lord.
according to you would have been continued in Group D.
Yes, my lord.
No, no, no.
But why 2004 petition challenged in 2021?
My lord, there is obviously, there is a, my
Go and take it further.
lord, I invite your lordship's attention for only for annexure A15. My lord, 1 minute, my lord.
Did any person junior to him, let's assume for a moment he has been reverted from APS to, when he was reverted, he was given
2004.
the GDS, not Group D.
No, GDS only.
Any of the junior to him in GDS has been given promotion to Group D?
No, my lord. No,
No
my lord.
one.
No, my lord. This is the list of the promotion which was made during 2003, my lord. His name is at serial number 551.
Just give it to him also, ma'am.
Yes. Yes.
Where is it?
His name is at 551, my lord. Serial number 551.
Yes. And
And now, during 2003, my lord, who was at serial number 369, was given promotion. There are 2 channels of promotion, my lord. My lord, by writing the departmental examination and by seniority and medical fitness. And if he would have written for examination, he would have got it. And during 2016, he got a transfer to Bangalore on the condition that he should be kept junior to the others. And he is not barred from taking the departmental examination for promotion to MTS. From GDS to
promotion to Group D.
a Group D, yes. It is now called MTS.
It's called MT.
Yes. And now, during 2023, promotion is given who was placed at serial number 369 during the 2003 promotion list.
369.
Yes, his turn has not yet come. Even junior to him has not got any promotion.
Seniors have not got.
Yes, yes, yes.
Seniors have not.
Yes, yes, yes.
So you are at serial number 300.
69.
On which date?
2023, my lord. Last year.
Now, suppose when he prematurely comes from APS, prematurely, he was given the position as GDS.
Yes.
Not Group D.
Not Group D. Because terms and conditions says so, my lord.
Which is that term?
Yes, I have produced it at annexure R6 at page number 104, my lord.
No, R1.
Condition A, my lord. This was during 1997, during the deputation to APS. Condition A, I will not seek repatriation to the civil before my appointment to Group D cadre on my term. In case of reversion to civil for any unforeseen reasons before my term for appointment of Group D comes, I may ready to be accommodated in any post of EDA if the present post, name of the present post is not available. If no, he was in GDS, my lord. If no post of ADA would be available in my recruiting unit, I will wait for appointment as much without claiming remuneration till a vacancy arises.
In any case, Mr. Ola,
Yes, ma'am.
once you come from APS, you will not be accommodated in group.
Right, now kindly see me the terms and conditions, R1 produced by her only, 93 page. This is undertaking given in pursuance of this annexure R1, my lord, page 93, which says, from paragraph 3, I will read, my lord. EDS officials who are now proposed to be regularized as Group D.
I put copies at annexure 9, page number 9.
Sir, will rank unanimous in the seniority of the civil upgradation. The child will be the data of entry in the civil relation. Your service and then for all purposes. This will not endure for your benefit.
My lord, this is, yes.
You have come back on your own request from APS.
Yes, ma'am.
What will it result in? You will be at the bottom of the senior part. Except the little window that APS service will be counted for the purpose of eligibility to do it. That's all.
Yes.
So now let's see what is the effect. You sought premature.
Yes, ma'am.
Your original seniority will not be there. When you went to the APS,
Yes, ma'am.
it will not be there. It will still rank less. Further, when you were posted at which place?
No, Kolar, some place, Nallahalla or somewhere.
When you were posted, you sought transfer to Bangalore.
That is subsequent, madam.
What we are saying is, there is already a downgradation in the seniority position. There is a further downgradation when you.
My lord, my submission is that, my lord, seniority of GDS becomes irrelevant when you was working as Group D. Should have been given an option, either to take retirement from there only, compulsory, I mean, whatever it is, or accept the post, whatever is offered to him.
It's all transpired in 2004.
My lord, 1 minute, my lord, your lordship may kindly see, in similar matter, my lord, page 82, annexure A15. Regularization order has been issued on the similar person, 5th August 2022, regularizing his services,
Page
82, my lord, of my son.
of your petition.
Yes, my lord. This I am produced only for the limited extent, my lord. There was delay in this case also, because it was regularized with effect from 7th February 1998 by an order dated 5th August 2022. Similar case. In pursuance of the orders contained in the Postmaster General, Hyderabad region, Hyderabad memo number so and so dated 29/7/2022, competent authority has ordered for service of the following BGDS personnel who was sent to Army Postal Service on deputation after giving him 1-day technical appointment as Group D to be regularized with effect from the date mentioned below. The official is eligible for old pension scheme under CCS pension rules 1972. And I leave it to your lordship.
That's one thing. Is he a person who has come on his own request? His seniority has been maintained?
No, no. Own request, correct, ma'am, with permission of the army. I have not deserted the post. I have not deserted the post.
One is saying so. Only one is saying is if you seek premature, the seniority gets affected. We don't know insofar as this gentleman is concerned. He has come on his own request. His seniority has not been affected. Rather, he got the benefit in terms of this one. We don't know. All in the realm of speculation.
No, just for sake of delay, your lordship said, I'm pointing out this, that's all.
Only saying deserter. See, your employment, they have to protect your employment. How can they say you are a deserter? They themselves have allowed you to receive repatriation. That's right.
True, my lord, but only question is, before offering the GDS post, this consent could have been obtained from the department.
If the day is so, like, 17 years down the line, we challenge it. Thank you.
My lord, even.
You want to press this, please?
My lord, I can't withdraw this.
My lord, even after repatriation during 2004, his seniority list is not affected, my lord. Their seniority only is given. Yes.
That seniority?
Yes, yes.
But wait, the challenge in this petition is to an order dated 6/11/23, passed by the Central Administrative Tribunal in July 70/00/00086 of 2020, whereby the tribunal has dismissed the original application filed by the petitioner by stating in paragraph 14 as under. Of the petitioner is and working as is it GDS or MTS when he was posted in APS?
He was actually Group D. Now thereafter it was redesignated as
GDS. He was sent on deputation to Army Postal Service in the year 1997. It's a conceded case of the petitioner that he sought his repatriation for personal reasons to the respondents who stopped. He continued to work as GDS as of today. So while on his repatriation from APS, he was posted at Kolar Division on 17/10/2004. He continued to work in Kolar Division, Division till 2016, when he sought his posting in Bangalore on his own as his own request. The resultant effect thereof is that the petitioner was placed at the bottom of seniority list in the Bangalore division. Submission of Mr. Holal and a counsel for the petitioner is that when the petitioner was repatriated to the respondents as GDS, the respondent should have given an option to the petitioner either to be given a Group B post or seek voluntary retirement.
Yes, my lord, because
Seek voluntary retirement. Unfortunately, the same has not been done by the respondent, which resulted in is not getting promotion to Group B. On the other hand, the counsel for the respondent would submit that that though on repatriation to the respondents from APS, his seniority has not been effected, but none of the juniors to the petitioner has been promoted to Group B. According to her, as per the seniority position, the petitioner's name
551.
The petitioner's name is at serial number 551. But as it was 551, as it is that, it is only the person at serial number 369.
Yes.
Who has got the promotion to Group D.
During 2023.
In the year 2023.
Group D/MTS, now it is resignating.
D/MTS to 369. And in that sense, there cannot be any grievance for the petitioner to seek promotion to the post of Group D. Because in view of the submission made by the legal counsel for the respondents, and also the fact that the submission of Mr. Ola, that the petitioner should have been given the Group D post on his repatriation, does not appeal us for the simple reason that any grievance of the petitioner not being posted in Group B was in the year 2004. Whereas the OA was filed in the year 2021. In other words, it is quite late in the day for the petitioner to agitate the said grievance. We do not see any merit in the petition, the same is dismissed.
Wait. 27.
Lord, I represent, Lord. Lord, the petitioner is the third respondent before the tribunal. My Lord. There are two applications were filed by the third respondent hearing. My Lord, before going to facts, my Lord, since 1 week, my Lord, about 300 persons have lost their lives in Wayanad because of the landslide. In that connection, my Lord, paragraph page number 270, 268, my Lord, 260, 271, maybe, 260, 270, page number. Huge trees are permitted to be felled by permit, where, my Lord, the third respondent, who was then a DCF in Virajpete. I will take number, page 276. A color photo, my Lord, Google map. Last but 260. There, my Lord, kindly, there is a boundary, Kerala boundary, state boundary, Wayanad Wild Sanctuary. Just above it, my Lord, kindly, my Lord, got it, my Lord. The numbers, my Lord, 01, 02, 007, 018, 019, etc. These are the trees, my Lord, felled by, my Lord, permitted to be felled by the third respondent while he was a DCF so and so. Whereas, my Lord, the permission was sought only for 6 trees. My Lord, the records were fabricated to show that 66 trees. An inquiry was held. Thereafter, inquiry, I will just take, my Lord, 2 lines of the. Yes. My Lord, right. No, just I am taking, my Lord, why I am posted there. Why I am posted, why he was suspended. Yes. No, that is not, where I am not there. My Lord. Yes. Yes. No, my Lord. Yes.
He can be posted here.
Yes.
And this is the carded post.
Yes.
That's all.
Yes.
And the tribunal comes to a conclusion, it's a carded post, it should be manned by an Indian Forest Service.
Yes.
That's the only issue.
Yes. 2 things, my Lord, I have to.
You are for whom?
I am for the third respondent, my Lord, non-cadre officer, SFS officer. The applicant, my Lord, is the cadre officer. He himself.
Yeah, no.
No, I am not.
You are the third respondent.
Third respondent in applicant place, my Lord, I was posted, transferred.
Now tell us.
Yes. No, my Lord, the applicant,
The Tata Service officer.
no, my Lord.
Now telling is the Bangalore posting is to be given to a cadre officer.
Yes.
Then how do you?
2 things, but 2 things. Such a contention could. But 2 things, my Lord. The applicant, who was a cadre officer, my Lord, while he was a SFS officer, why he was a SFS state forest officer, now himself beneficiary, and he held such a cadre post for 5 years, 10 months. That is one aspect.
One should have challenged.
Yes, no. Then now at present, Lord, there are 11 non-cadre officers are working in the cadre posts. But why I should be singled out? Let there is a provision for the government to seek approval.
Can we say that though the rule says it should be manned by a cadre officer, if a state cadre officer gets appointed, it is just and valid?
No. Certain, no. This is one. There are 2 things, Lord, such a contention, Lord, could not have accepted by the tribunal at the instance of a person who held an officer who himself non-cadre officer. One thing. Second aspect, Lord, there are 11 officers of non-cadre officers are now working in cadre post. My submission, Lord, my post alone cannot be reviewed, Lord, by the government. If the government has a provision to seek approval of central government, kindly see, I will take rules similar. Page number that has.
This gentleman who is now respondent number 3.
Yes.
Posted in Bangalore.
Yes.
This startup.
Yes.
Said I have a feeling. See, difficulty is this.
No.
7. People may not be agreed.
Yes,
So saying we are not posted there, why should we say?
yes.
The state forest officers are continuing. He says, insofar this post is concerned, I was posted,
No, why?
hence I must get it.
That's why I took the photos. He is the serious culprit, my lord, who permitted, my lord, about 66, 100 old tree trees, my lord.
He has done.
Yes, the publicant before trial.
There is a penalty imposed on him.
Not at the inquiry is under progress.
In any case, for whatever.
That is separate. I am not agreed. My lord, both now the application has been dismissed by the tribunal. While dismissing, my lord, a direction issued to the government to review my posting in so and so on. My submission, kindly see, my lord, the state government still has a power to seek approval. Page number 24.
Third respondent.
No, I am not. I have no grievance, but he has also no grievance because his application has been dismissed. He has no grievance. Yes. The third respondent, who's the applicant, has challenged my transfer order. Chakrapani.
Before the tribunal.
Tribunal, my lord, I just take, my lord.
You participated in the tribunal?
Who? Myself, my lord. Yes. I am third respondent.
Sir, Ravinder-
Yes. Page number 20.
Now, in this appeal, had made him a party.
Ravindra Kumar is filing appeal.
Mr. Chakrabarti.
Chakrapani is third respondent. Is formal party, my lord. We have no grievance against him. Lord, he has his application filed seeking the challenge to my transfer has been dismissed. He has not challenged this. As a formal party, I have made him. He has no grievance.
Let's see the order of the tribunal.
Tribunal dismissed, my lord, his application. Page number, operative question. Page 45. Ink page 45, internal page 26. The prayer of the applicant, that is Chakrapani, seeking posting as Deputy Conservator of Forest, Bangalore Urban Division, is dismissed. In further direction, I am agreeing. The responding state government is directed to review. Yes.
And the respondent state government directed to review the appointment of respondent in the state.
Forest officer. Yes. My submission, two submission, my lord. Such a direction, my lord, tribunal has travelled beyond the actual scope of the petition. One. Second, my lord, he himself is the beneficiary for more than 5 years, 10 months he held office. Yes, as a dismissed. Not his claim has been, his application has been dismissed, but he is the beneficiary. He being a state forest officer held a cadre post for 5 years, more than 5 years. Like him, my lord, for his place, my lord, I have the petition has been posted. His posting has been transferred with Chakrapani. Now there are another 11 persons are there. Now directions issued only to review my posting. Therefore, my submission, my lord, though a narrow scope, my lord, the government may be directed to review all the posts in that viewing.
Say nothing. What you are arguing is also applicable to us. Can we go beyond the prayer?
Yes.
That's right.
My lord.
7 are not before us, not before the tribunal.
Yes.
That's right. Same implies.
My submission, my lord, kindly see, my lord. Now, my lord, there is a provision for the state government to review, kindly see.
Insofar as Mr. Chakrabarti's
Is
prayer is
rejected.
the tribunal has given this.
Yes.
Okay.
Yes.
And what is wrong insofar as this direction?
Now, my submission, my lord, I have placed before the tribunal material to show that, like me, there are 11 persons are working who are state cadre officer, state non-cadre officer, that is state forest officer in the cadre post. Why I should be alone? My posting only reviewed, my lord, my submission, my lord. There are similarly, 11 persons are there who are working for more than 1 year, 2 years, etc. Let the government take a decision, my lord. I will respect all the. Yes, my lord is right.
This post of DCA, urban Bangalore,
Is cadre post.
is a data post. So this direction to ensure that the post is filled by a suitable cadre officer is not illegal.
No, madam, it's not. But at the same time, Lord, such a direction could not have been given my submission because I am not the only person.
Can songs make one right?
No.
That's the.
There, my submission, Lord, there is another point, Lord. Another point is Rule 9 it has been quoted, called in paragraph page 24 of the internal page of the order.
Which page?
Page 43, Lord. Rule 9 has been called out. There is one problem, there is small area, my lord, where I can see. Rule 9, my lord, has been called out. Rule 9 says, my lord. Yes, IFS scanners. It has been called out here, my lord, just as. Now see, my lord, kindly see, peruse, my lord. Temporary appointment of non-cadre officer to cadre post. Rule 9 1A. A cadre post in state shall not be filled by a person who is not a cadre officer, except in the following cases, namely, if there is no suitable cadre officer available for filling the vacancy, provided that when a suitable cadre officer becomes available, the person who is not a cadre officer shall be replaced by a cadre officer. Then, provided further that if it is proposed to continue the person who is not a cadre officer beyond a period of 3 months, the state government shall obtain the prior approval of the central government for such continuance. To that extent, my lord, the government may seek, otherwise.
I should say the itself is clear. It calls out.
When there are 11 officers are working in the.
11 officers are not before this petition. Let's be very clear. What you are arguing is also hold good for this submission. How can we go beyond this? And mind it, the state government is within its power. The rule 9 is very clear.
Yes.
That's all. They must act. There is a direction, they must act.
My submission.
Officer, rule 9 will come into play.
For my submission, my lord, the tribunal having dismissed, my lord, the application of the Chakrapan, stop there itself. That further objection, observation, my lord, may not be called for. To that extent.
What is the title?
No, not his attempt. His suspension also dismissed. Suspension, there are 2 applications. He was suspended, Chakrapani was suspended. He challenged one petition. While pending the suspension, my lord, no stay was granted. He approached the Disciplinary court. The Disciplinary court granted interim order, staying the suspension order. During that period, my lord, I was posted. And my transfer order was also he has challenged. Both applications have been dismissed. Tribunal could have stopped there itself.
Rule 9 is there.
Yes, my lord.
That they will, state government has to act under rule 9.
Yes, my lord.
Simple. If there are no officers are there, possibly they may say, okay, very well, you are there, you may be posted.
That's why now, my lord.
I do think that the state government will not act in accordance with rule 9.
That is one much. My submission, the tribunal should have stopped there itself. That's the only thing.
What the tribunal suggest goes, there is a charge sheet which is pending against him.
Against Chakrapani.
Not give a direction for him to be appointed.
Yes, no, because yes, no, he was given some other posting.
So far as this rule 9 is there, whatever is the.
No,
The state government is required to look into rule 9.
Yes, let them act, not at the hand, not with this direction, my lord. My lord, my submission.
Rather than you should not have even filed this. Let the state government act on it. They have a rule 9 to fall back upon.
My submission, tribunal should have stopped there itself, Lord. Not that such a direction ought not to have been issued at the direction of person, Lord, who is the culprit, Lord, giving such a permission, Lord.
To that post, being a cadre officer.
But he involved such a grass.
That's the reason he did not get that posting.
Yes.
Getting the point? We don't know, you want to withdraw it or what? See, the rule 9 is very clear.
Tomorrow, Lord, let's take instruction.
For
For withdrawing.
For what?
For withdrawing, seek instruction.
Take instruction. Also, take instruction.
Tomorrow, Lord,
Tomorrow.
please.
Exceed.
Please.
Thank you.
Oblige.
Serial number 28, VS Naik.
I appear for the.
Please, my lord. This, my lord, there are totally 3 writ petitions, out of which 2 writ petitions are in respect of same award. Both work employee as well as the management have questioned the very same award. That is 3925 of 2021 is filed by the management, challenging the award passed against
Central Agriculture Research and Training Institute and the Central Silk Board.
Central Silk Board is the parent body, under which there are several other
Another unit.
units. There are several units relating to sericulture, mulberry seeds, seed project, everything is there. Number of units are there.
Now, 3925 of 21 is filed by the management, challenging the award passed by the Central Government Industrial Tribunal. Very same award, my lord, is questioned by the employee also in 7144 of 2022. And another writ petition is relating to another employee, not related to this, 2027 of 21, is filed by the employee against the rejection of the reference. Now, my request is, Lordship could take up 3925 of 21 and connected writ petitions first. Now, this 3925 of 21, my lord, is filed by the management, challenging the award passed by Central Government Industrial Tribunal, wherein the tribunal has directed the management to pay 80% of the back wages to the employee. Now, brief facts are like this. The respondent, he was working as a clerk, lower division clerk in the Central Silk Board. He was issued with a charge sheet alleging 4 different charges in respect of 28.2. I don't have the list number one.
7144.
That is the writ petition filed by the employee against the very same award worker, where I am the respondent. Nimdu.
Just pass on, Mr. Narayan.
Please.
For the petitions, it will take some time. Pass on.
Lord, sorry, earlier, the previous matter, Lord, maybe dismissed as withdrawn. That's all right.
After some submission and answer for the petitioner states that he had instructions to
Yes,
withdraw.
yes, sorry. Please.
Please.
Can we have it another day?
I have one matter. Complete that I come.
Yeah, we have a partner matter, we want to hear that matter.
Very well, very well. Very well.
29, Mukanappa.
Please, my lord, I am for the respondent, my lord. So I'm requesting to grant 3 weeks' time to file the statement of objection by the court.
This is from CAT, no?
Yes.
Do you require objections? You will consider the,
No, they have sent mail, my lord, I have to. They have considered the mail, my lord, to all the instructions to us.
just one.
My lord.
Yes. Yes, tell us.
Day after tomorrow, morning, I see.
What is a small issue? We will assist you. Come. Your whole case is this upgraded to 1640?
Yes,
You are the counsel?
yes, my lord.
Yes. Small issue.
My lord, senior will argue the matter. Day after tomorrow, my lord.
But senior for us. Come.
Well, I informed to senior, I'm seeking the time, that's.
Day after tomorrow.
Much.
7, 8,
No need, we'll have it there.
Please.
7, 8, sir. Seal number 30, Shri Kulkarni.
I beg to appear for petitioner, my lords.
Yes, Mr. Kulkarni, what is this?
My lords, I belong to All India Service Cadre of Indian Forest Service. I retired on 31/7/2018.
Yes.
My gratuity amount was not released by the government on the ground that a case was pending against me, disciplinary proceedings initiated in 2013.
TCS pension.
And in respect of that 2013 charge sheet, which I have produced before your lordships in this writ petition also, a punishment came to be imposed against me after my retirement, holding my last two increments prospectively affecting my pension. That has been set aside by the Honorable Tribunal and left it at that. Your lordship may kindly see that order, page 48.
For the same charge?
Yes, my lords. The operative portion your lordships are seeing on page 57 and 58, paragraph 9. In the light of the aforesaid judgment, the order at Annexure A3 issued by respondent number 1 is not sustainable. That is the punishment order in A3. Hence, deserves to be set aside. Accordingly, we pass the following order. Impugned order bearing number so and so, issued by the DPAR, Government of Karnataka, respondent 1, Annexure A3 is set aside. OA stands disposed of as indicated above, no order has to cast. My submission to your lordship is, once that punishment is set aside by the Honorable Tribunal, without giving any room for the department to go ahead with the matter, what they have done is they have issued a order for 5% cut thereafter, which was under challenge in the second OE. That punishment order, page 59, your lordship.
But tell us, Mr. Kulkarni.
Yes, my lords.
What the tribunal has set aside only on the ground that it cannot be retrospective.
Yes, my lords.
That's right. Let's
Yes,
assume for a moment cannot be, and rightly so, it cannot be retrospective.
Yes,
surely it can be prospective.
No, I retired by then.
It's all right. You are retired by then, but where is the punishment for a charge sheet?
My submission to your lordship is, if the punishment has to be given to the charge sheet in question, the tribunal has kept open that ground to the department.
Pardon?
Tribunal has kept it open to the department to.
Okay, let's take that way. Very well, very well. Let's take that way. So it's open for the department to impose a fresh penalty, keeping in view the fact that you are a pensioner.
Yes, my lords.
Okay. Now, what does the tribunal say in this matter?
Tribunal did not say anything except that the punishment imposed is wrong and therefore it is set aside and left it at that.
That's right. Now, that's the first round of litigation.
Yes, my lords.
Now come to page 17.
Kindly see page 59, the second this thing which is under challenge before your lordships. That is the second round of litigation, page 59.
That's right.
In this, what has been done is, your lordship may kindly see page 61.
Yes. Now this is a show cause.
Yes, they say that if your lordships are to hold what the tribunal has held that it is a show cause notice, I am out of court. But my humble submission to lordship is, it is not in the fashion of the show cause notice. Kindly have a look to the contents of that order.
Yes.
In the departmental inquiry initiated, page 61, I am reading, my lords. In the departmental inquiry initiated against you at GO dated reference number 1, a penalty of withholding of 2 annual increments falling on 1/7/2017 up to 31/7/2018 with cumulative effect affecting your pension was imposed. Against this penalty order in OA 1293 of 2019 filed by you, Honorable CAT Bangalore Bench wide order dated 7/3/2023 is pleased to set aside the said penalty order. Therefore, government has decided to pass a fresh penalty order in lieu of the penalty imposed under reference number 1 of the government order by imposing a penalty of 5% pension cut for a period of 5 years. You are therefore called upon is the last paragraph on page 62. My humble submission to your lordship is government has already made up her mind that to imposition of 5% pension cut.
Okay. So you say it's not a proposed punishment.
It is not a proposed punishment. The tribunal ought to have examined the merits of my OA in that connection.
No, see, one thing is there. Let's be very clear. In the first round of litigation, your findings, everything have not been interfered. What has been said by the tribunal is that it cannot be retrospective. In other words, it has to be prospective.
Yes, prospective punishment, the punishment imposed earlier could not have been effected prospectively because of my retirement in the meanwhile.
So it
There
necessarily.
punishment order is also issued after retirement only.
Okay. So you say that this is a conclusive decision, not
Yes,
a proposed penalty.
Yes, my lord. Not as a proposed. They want to cut 5% pension. That's what they have stated.
That's right.
A empty formality has been done in the last paragraph.
Very well. There are two things. You can file a reply to this. Have you filed a reply?
No, tribunal has stated that the punishment, the order which is imposed before imputed before lordship is, tribunal has stated it is only a show cause notice. Therefore, you have to file a reply.
That's right.
My submission to your lordship is the punishment imposed earlier also is a minor penalty. Is a minor penalty. Your lordships are aware President's power to invoke Rule 9 for imposing the pension cut or anything is only in respect of grave misconduct and grave negligence. In DV
that graveness would be seen by the competent authority, Mr. Kulkarni. We will not.
I agree, my lord. That graveness has been already seen by them, and they thought that it is fit for imposing two pension cut, increment cut.
Okay. Now tell us what precludes you to take all these pleas in reply to show cause.
My humble submission is that DCRG is not released since 2018. DCRG ought to have been released by them. It is my submission. And blocking up that DCRG with reference to this is impermissible. Because no such a punishment.
We say nothing. See, pension includes gratuity under the rules.
No, it's a separate. It's a pensionary benefit.
That's right. That's what we are saying. Pension includes gratuity.
My lord, I submit that it is pensionary benefit.
Very well. That's a nomenclature only. I think possibly we are at the same page. Maybe a pensionary benefit or pension includes gratuity. Let's not go into the nomenclatures.
No. That is not relevant also, actually.
Yes. Now, 5% of pension, what do they want to really impose a penalty? Appropriate would be for you to take all these pleas in your reply to show cause notice.
But it is only
rightly so.
the proceedings, my lord.
Pardon?
It is only protracting the proceedings against me. And I retired in 2018. Now by this time, 65, 66.
Right. But there has to be a.
How long I have to suffer? 2013 onwards, for no fault of mine, I am suffering.
But see, but for the litigation, maybe they would have flashed the order also.
No, I have not done any litigation.
The OA before the tribunal and this writ petition, possibly if you have allowed it, they would have passed an order also.
5% pension cut. Again, I will have to go back to the tribunal.
We don't know.
That is what if they have proposed why punishment should not be imposed under Rule 9 pension rules, I can understand that. I would have answered that, show cause notice. What they are now doing is, government has decided to cut pension, 5% pension cut. And a formality has been, empty formality has been done in the last paragraph that why you have any say, you say. Where is the question of my say at that stage?
They have not said anything on the gratuity in the show cause.
They have not said anything about the gratuity.
Well, it's good. If they have not said so, the
But
show
they have
cause.
not released it so far.
Pardon?
They have not released it so far, therefore I am before your lordships.
So, very well. Yes, what do you say on this? You have not said anything on gratuity. Why don't you release the gratuity?
The part of.
No. See, it appears so, and you're right, but if you see this.
Page 61 minutes.
Have they given you any communication where they say they are forfeiting the gratuity also?
No, my lords.
You have not said so, no? I think Mr. Kulkarni, better would be you give a reply to the show cause notice and take all your pleas. And possibly you must also say that you have not released the gratuity till date. And then let them come out. And we can possibly, give a specified time period directions. Okay?
I understand that, my lords, but my submission to your lordship is whether am I to suffer this agony?
See,
In
we allow them to pass an order. See, we can't presuppose and we can't set aside even the show cause notice. See, there is a charge sheet issued. It must end with a final order. Either way, a final order absolving you of the charges or any penalty that may be imposed. Then
Yes.
you will have a right.
I understand that, my lords. Technically what your lordships are telling, he has to hold the field. That is different issue. But my humble submission to your lordship is in the punishment order presently earlier imposed, and after setting aside that disciplinary proceeding comes to an end in my humble submission.
No, that we can't agree.
Unless tribunal gives them the right to pass orders under Rule 9.
But we thought that you are not saying so. You thought that they are within their rights to issue the show cause notice.
I accept that.
If that be so, then you must reply.
It is not a show cause notice, it is only simple submission of mine, my lords.
You are right. But you are right. You are right. The show cause notice is not happily worded. They should have said it's a provisional subject to what you say.
In service matters, my lords, my humble submission is whatever the words employed will be the cause of action. The always government does in that manner only.
What do you want now? Tell us.
No, one simple request of mine to your lordship is, as your lordships are suggesting, I will give a reply during the pendency of this writ petition.
No,
And then your lordship.
We will dispose it off. We don't want while pending this petition, the application. Let there be a proper application of mine without being, influenced by the proceedings pending. We'll say so.
Your lordships are applying proper application of mind only.
Pardon?
Your lordship's proper application of mind only, that is.
So
what your lordships are telling is go before the tribunal once again after passing the order.
We say nothing on that, Mr. Kulkarni.
I understand that, but it amounts to that.
Suppose you are absolved. There is no requirement for you to.
There is no possibility of absolving because they want something. The entire proceedings are like that.
We can't foresee that. What do you want? Tell us, please.
My submission is at least your lordship may direct releasing of the gratuity immediately, and then I will be your lordships with that disposal.
I don't think. We will only confine. We will not. I don't think we should really.
But that was the prayer before the tribunal, my lords.
Just 1 minute. Just hold on. The petition has been filed by the petitioner challenging the order of the tribunal, Central Administrative Tribunal, dated 23rd February 2024. Whereby the tribunal has in paragraphs 4, 5, 6, 7 has stated as under. The submission of Mr. Kulkarni and a counsel for the petitioner is that the show cause notice on which the so-called notice which was under consideration before the tribunal dated 25/1/2024 is conclusive on the fact that the respondents intends to impose a penalty of 5% pension cut for a period of 5 years. In other words, it is his submission that the same is not a provisional view of the respondents. Full stop. Under such circumstances, it is not expected that the respondent shall consider the reply to be given by the petitioner in a proper perspective. Full stop. Though the submission made by Mr. Kulkarni looks appealing, comma, appropriate shall be that the petitioner shall give reply to the show cause notice, taking all pleas, including the plea which has been urged by Mr. Kulkarni before us today. Full stop. The reply, if not already filed, be filed within a period of how much time, Mr. Kulkarni?
1 week is enough for me.
1 week to enable the respondents. Who has to pass the order?
The government, so now it happens, after this thing, they will have to send it to the Union Public Service Commission again. And after getting the recommendations, they will have to forward it to the central government.
Oh, they have to do it to UPSC.
Yes, because UPSC only suggested a 2 increment cut. Based on that, directly they have passed that order without going into that.
Very well. Okay. Then we will full stop to enable the respondents pass an order on the show cause notice. How much time you want? 2 months. Shall be done as expeditiously as possible within a period of 8 weeks from today. 8 weeks from the receipt of the copy of the order. Full stop. The petition is disposed of. Can Mr. Chawta come? You have your matter.
I am obliged to my lords.
Thank you, Mr. Kulkarni.
Translated copies of the ground of detention minutes.
Your ground is they are not legible.
No, I'll just point out, my lords, the most important case of theirs, which they talk about the JJ Act, which I will just point that out, how they have given us the papers on the JJ Act.
These are the type copies.
Yes, my lords, now we typed this and
You got it
we
typed.
got it typed because my lords,
There is nothing.
no, it
illegible.
is. Now it looks much more legible, my lords,
Much more.
much more legible and
It cannot be better.
it can't be better than this. My lords,
served upon us. The direction, right?
it is a translated copy of the same spiral bound translated copy. It's what you have given us as grounds of detention, nothing else.
Even otherwise,
Which
if you're
is
relying upon it.
Set the grounds of detention. Nimatra, grounds of detention ilva. Adidhyala, ade same translated copy, nothing else in this, which you have given. My lords,
Just 1 minute
Yes.
so that we can discharge the board. Mr.
please, please.
Then we can give this dates also. 31, whatever remaining matters, no? Just give dates. See, we'll discharge the board. The dates would be given by the court office later. So Narayan Swami, I don't think this would take time. I think good for the day. We'll give you dates. You can have it afterwards. Yes.
Well, it's from what I've just passed on now. Of these 7 cases, my lords, the grievance appeared to be in a case where the Juvenile Justice Act was invoked. My lords, the Juvenile Justice Act which was invoked was in crime number 417 of 2023, my lords. 417 of 2023. My lords may have kindly have page 3, my lords. On the next page of page 3, my lords, on the next page, right at the bottom, my lords. Wood bond number 161. My apology, my lords. It's a second page, Ali. Second portion, just above serial number 21,
we get crime number 417, where my lord should notice Juvenile Justice Act. Second page, Ali, how that really page 3. This is what they had given as grounds of detention. This in Kannada. I'll show the English version also there, my lords, just to show it's the same. Page 3 on the next page, my lords, which is unnumbered, right on top, crime number 417 of 2023. Page 3 on the back portion of page
So
3.
we have page 3A, B, C.
My lords may come to 3A, my lords, which is the typed copy of it. The relevant portion will be 3C, my lords, 3C. Because we wanted to maintain the same page numbers. That's the reason in translation we've done this, my lords. Page 3C, after serial number 20, we get Basweshwar Nagar Police Station, crime number 417, under so-and-so JJ Act. We get 78 of JJ Act. My lords, below that, serial number 21, first information report, page 161 to 166, and then they go with certified copy of PF, certified copy of so-and-so. Kindly notice page 161, my lords.
You've given the same pagination.
Yes, my lords, we've given the same page.
That's a reason you start using alphabets to meet the pagination.
Pagination, my lords. Because A, B, C becomes easier when we trans. So, my lords, if page 161 is noticed, there is no FIR itself provided. They don't give the FIR nor the complaint. Though in the index sheet, my lords, they say FIR, first information report between page 161 to 166. If the corresponding page is noticed, my lords, it's only PFs that have been given without even making available a copy of the FIR or complaint. So 161 is PF number 202, my lords, and 161A, we have translated it.
PF.
Similarly, 163 onwards also may be noticed, my lords. So they straight away go to 164, which is one other FIR in crime 419, my lords. 419 at page 164. It's a different crime. So, my lords, one of the grounds normally we see is for me to give a representation, the grounds of detention which they're going to be relying on, all the copies need to be served to me so that I can at least afford this opportunity of giving a representation. This is one aspect. So, main aspect of their case on JJ Act, my lords, in my respectful submission, will not hold any ground, my lords. My lords, I had pointed out through the detention order itself, my lords, 2 points I had pointed out, my lords. One is on the aspect of the vagueness in the detention order, where though they want to proceed against me as a gambler, they loosely use the word Gunda against me. So Gunda they put, and then they show gambler, and then they say because of gambling, I'm sought to be detained. So there's vagueness to that extent is one aspect that I pointed out, my lords. And the other aspect I pointed out was the detention order by the Commissioner of Police. He says by exercising powers under 3.1 is what he says. Though, my lords, what probably he would intend is 3.2, subdelegation. Now, my lords, kindly notice the detention order for one more minute, my lords, because I find in the detention order, page 152, my lords.
Yes.
There seems to be about 4 or 5 aspects which are not in consonance with what could be a detention order, my lords. The first aspect that I wanted to point out is, it's not clear or precise. Are you detaining me as a gambler defined under the Act, or you want to detain me as a Gunda? Please notice that, my lords, line 4 from the top, after saying I so-and-so, Commissioner of Police, Bangalore City, I'm satisfied that so-and-so is a Gunda and habitual gambler. My lords would get those 2 words right in the 4th line. And then further down, line about 8, my lords, with a view to prevent him from gambling activity. Now, my lords, a detention order should be clear and specific as to what is the reason for you to detain me.
Yes.
Please notice the next paragraphs where I said specifically he exercised powers. My lords, in the next
Yes.
paragraph, I pointed out, he specifically says he exercised powers under section 1 of section 3. That is how he goes about it. But my learned friend was pleased to point out that there's a government notification below that, which is extracted. Now, please notice this government notification. This government notification number HD 278 SST bar to 2023. Now, if it is 2023, how could it then be dated 3/6/2024? Kindly notice the notification, my lords.
That's right, but would that make any difference, Mr.? For the simple reason, ultimately it came into existence on 3/6/24.
That they may have to point out, my lords. Probably when my lords.
This cannot be a subject matter of confusion.
How
would you be?
No, my lords, with the power they had. It goes to the root of the matter, whether he had subdelegated power. If the commissioner did not have a subdelegated power, which, my lords, is only valid for a period of 3 months, then he can't pass a detention order. It can only be the government.
But surely at least 3/6/24 he had.
We
Let's
don't-
assume. We don't know.
Yes, my lords, it's subject to, please.
But the date being there, and
The-
then the order being on 10/6, it is within 3 months.
If it is taken as 3/6 and 10/6 is within, but if it's taken as this government notification of 2023, my lords, then there may be some
We'll
point
ask-
which, yes, my
we'll
lords.
ask.
Now, the third aspect is, my lords. Now, the third aspect here I find is, my lords. Normally, my lords, in all fairness, the period of detention should be in the detention order. I should know, my lords, for how long I'm being detained for this act of me being a gambler, my lords. I'm not a gunda or I'm not a terrorist, but you're showing me as a gambler. So you should tell me for what period of time am I being preventively detained. That is not there in the detention order at all.
Is not there?
No, my lords, it is not there. Now here I may also add, my lords, we do have some judgments, my lords, which says, all right, even if it is not there, still it could be valid is how they would proceed, my lords. Those are cases where serious offenses are alleged and there's no period done. And subsequently, my lords, it would have become 12 months by the government. But in cases of this nature, my lords, where they want to put me in as a gambler, the period not being there, and when these records go before the advisory board, my lords, which consists of very esteemed persons looking into the matter, my lords, their opinion holds good, my lords, to the government. Now, when you're placing a matter of this nature before an advisory board, which does not even contain the period for which they're seeking to detain me, my lords, would it be fair to say, my lords, that the advisory board takes it one step up and leaves it to the government for confirmation? Now, during confirmation, you make it 12 years. What is not made known to me at the time of the detention order, at the confirmation becomes 12 months. This, my lords, I find in the judgment I relied on, my lords, the role of the advisory board. And after that, what should be the role of the government, they touched upon, my lords. They went to the extent of saying, look, ultimately, if there's a detention order saying it is for 12 months, it was placed before the advisory board. Advisory board also gave a positive note on that. Despite that, when you're doing the confirmation, you have the power, the government has the power to reduce it. You need not. My lords, when the advisory board gives an opinion, you can't proceed with the matter, then the government is bound by it. But vice versa, my lords, if the advisory board gives an opinion, no, we find sufficient ground, still the government can say, no, we are not going to be confirming it. That's how the act reads.
Tell us one thing, was this, so we are not concerned with the advisory board proceeding?
No, because it's confirmation.
In any case, was it urged before the advisory board?
But they did give representations, my lords, before the advisory board also. But probably, my lords, somewhere going more deep and saying, look, there is no date of detention. I don't think it was there in that representation also.
But in any case, we are not sitting over it.
No. We are going on the confirmation, my lords, because now once the detention order, the confirmation. So if confirmation, where I'm able to point out in the detention order itself, you don't spell out the period for which you're detaining me. It can't be at the time of confirmation, after which I don't have a remedy, my lords, like how it is to give a representation.
Also, they can reduce the period.
Yes, my lords, they can. But here, no period in this detention order, my lords. On the next page also, my lords would notice, there's nothing, my lords, nothing insofar as the period for which I'm being detained.
Yes.
My lords, what happens thereafter may amount to a bigger illegality, my lords, in my respectful submission. 10th was this date of order of detention. 13th, my lords, I would give a representation. And my lords, under the act, when a detention order is passed by a subdelegatee, then my lords, approval has to be done within 12 days by the state government. Now, in my case, my lords, 10th detention, 15th was approval by the state government within that period of 5 days. They've done that. 13th, my lords, when I give my representation, I will have to give it to the commissioner because the first order of detention is of the commissioner. I gave a representation to the commissioner. If my lords, along with the memo, we're producing it, the representation which I have given, my lords, it was a very detailed representation pointing out each and every case against me as to how it does not affect public order. It at best is a law and order. And I pointed out the whole reason of all this is because I gave representations against the police, my lords, that led to a backlash of all this. That is how a very detailed representation from page 1 till page 66, my lords, a detailed representation addressed to the Commissioner of Police. What they would do to this representation is, my lords, the only correspondence that we get here is page 67, dated 18/6/2024. There, the government who had also received this writes to the commissioner, consider that representation and give reply. This is all that we get. My lords, I am given to understand, my lords, we have not received any reply to this representation at all. On instructions, I say so, my lords, subject to, because they found out even from the detainee, did you receive any reply for your representation given to the then detaining authority? The answer they say is no, we did not receive anything.
This is the representation made on this material.
Yes, my lords.
On the material.
On the
or
material,
they have
yes, my
relied upon?
lords. Yes, my lords. On the material, the representation given to the Commissioner of Police and reference we get in their own letter, my lords, at page 67, that the government wrote to the Commissioner that such a representation, look into it. Now, we have not received a reply. That would go to the very base, my lords, where a representation is given. All the judgments would say it would be the responsibility of the detaining authority to consider the representation and give a reply. Now, representations could be repeated, my lords, but the judgments all say any number of representations you receive, you are bound to consider it, give a reply back to the same. And this can happen even after confirmation, my lords, because they always have the power, my lords, to recall their order. So even after confirmation takes place under section 14, if a detainee gives a representation, the government is bound to consider the representation. They can reject it, but they're bound to consider it. Now, in the first instance, when it's sent, my lords, more responsibility on the detaining authority to give a reply on it, my lords. A detailed representation that was given, my lords. This would be the other aspect I wanted to point out. And from the judgment, my lords, which I relied on, I only relied on one judgment, my lords. I thought that covers a lot of decisions, my lords. There, the role of the advisory board is spelled out in that particular judgment. Paragraph 67 may be noticed for a minute, my lords, in that judgment.
You have referred to a lot of judgments in this also.
We have referred to, yes, my lords.
Which
My
is
lords,
this one?
Probably, I'm sorry, my lords.
Which is this one you are relying upon?
Amina Begum, my lords. That was the only judgment that I relied on, Amina Begum, because I thought it's a very comprehensive decision, my lords. They've really considered all the aspects.
All the laws.
In that, my lords, paragraph 67 deals with advisory board, what would be expected then, and thereafter what is expected from the government, my lords. 67 to 69. These are the only paragraphs in that. It is page 626, my lords. paragraph 67.
Yes.
Commences, my lords. Now we proceed to answer the incidental issue raised before us. Seldom have we found orders of detention continued after the advice of the advisory board for less than the maximum period permissible under relevant laws. Consideration of the matter by the advisory board, which consists of respectable members, including retired high court judges and those qualified to become high court judges, was conceived to act as a safety valve against abuse of power by the detaining authority and or to check the possibility of grave injustice being caused to a detainee. It is one thing to say that the advisory board has expressed an opinion that there is sufficient cause for the detention and therefore the detention should be continued. Yet it is yet quite another thing to say that the detention should continue for the maximum period per permissible period. In the light of subsection 2 of section 11 read with subsection 1 of section 12 of the Act, the period for which the detention should continue is left to be specified by the government within the stipulation in section 13 thereof that the maximum period shall be 12 months from the date of detention. This appears on the plain reading of the relevant statutory provisions. That apart, Mr. So-and-so is right in placing reliance on the concurring judgment authored by Honorable Mr. Mukherjee in so-and-so that the duration for which a detainee is to be kept in detention is for the detaining authorities to decide and not the advisory board. The court opinion finds approval in the decision of the Constitution Bench of this court. In A.K. Roy versus Union of India, the period of detention and the terminal point has therefore to be decided by the government. Having observed the uncanny consistency of authorities continuing detention orders under the preventive detention laws for a maximum span of 12 months from the date of detention as a routine procedure without the barest of application of mind, we think that it is time to say a few words with a view to dissuade continuation of detention orders till the maximum permissible duration, unless some indication is provided therefore by the government concerned in the confirmation order. Then, my lords, Article 22(4), I would skip that, my lords. Then 69, what section 13 of the Act with which we are concerned provides has been noticed in one of the preceding paragraphs. However, the regular practice of authorities treating the maximum period of detention of 12 months as a standard duration in our view could be suggestive of a mechanical approach. Inherent in the conferment of powers to extend detention for 12 months is the discretion to make an order to be operative for any period less than the maximum period. So this is how they would view it, my lords. So I would say, my lords, if the detention order contains at least a period of detention, and when it goes to the advisory board, my lords, advisory board can always see on the basis of these grounds of detention, are they justified for having detention for this period, and accordingly could give their opinion also. But here, when we don't even have a period mentioned in the detention order, my lords, the advisory board itself would be lost of words to say, how is it that we can do? Either we approve this or we don't approve it. And as I pointed out, my lords, the whole state, this is only second occasion, my lords, where a person being defined as a gambler is put into detention, my lords. The first matter, when it went to the advisory board, they felt no grounds to continue. And the government was bound by it, they dropped. But unfortunately, when it happened to the second case here, my lords, advisory board gave an opinion, you can proceed, and confirmation is passed. So, my lords, when we look at the whole matter and the kind of cases 7980, which are non-cognizable offenses being used as a base to preventively detain a person, my lords, who is out on bail in all those cases, it would become extraordinarily harsh, my lords, a clear case where these preventive detention laws are sought to be misused, my lords. That cannot be the object of this act, my lords. One other aspect, my lords, I'll just... And my lords, on a specific aspect of saying they did not obtain license. My lords, for playing a game of cards like Rummy, my lords, In my respectful submission, there's no license required. Now, how it runs in all the clubs, my lords, in Bangalore, we have a number of clubs, my lords. In each of the clubs, there are various departments in it, my lords. We have a department dealing with badminton. We have a department dealing with tennis, so also squash. Like in the same fashion, my lords, the department dealing with cards is considered as a sport. It is not considered any different, my lords, in all the clubs. So to say you need a special license for badminton, no, you don't need it. It's considered a sport. Same when you're running for rummy, my lords, you don't need a license. So what most of them would do is, my lords, they get themselves registered as a society. Now all the clubs, even in Bangalore, get themselves registered under the Societies Registration Act. That's all that you have. After that, you have your own rules and regulations on the basis of which you proceed. Then you get the requisite, my lords, license insofar as excise is concerned, or if it's going to be tax or any other, we take licenses under that. But to say you need a specific license to have a game of rummy, probably in my respectful submission it is not required, my lords. So, my lords, these are the sum and substance.
Okay, that's all. Yes.
Please, my lords. And senior counsel, my lords, refer to the documents which is not been supplied.
Their own document.
417.
Translate. Yes.
417.
Huh?
417, crime number.
That is from your detention order. How to, that is from your grounds of detention. I have not. Page 3 alide in detention grounds ಅಲ್ಲಿ. Page 3 of your grounds of detention. How to, ಇದೆ spiral bound. ಅದರಲ್ಲಿ page 3 alide. They've given page 3 on the total. So that, my lords, we are relying on the same book. I'm just making sure that.
Learned senior laid upon the non-furnishing of document in crime number 417, my lord. I do have the copy of.
Period.
I do have the copy of this detention.
Pardon?
I do have the copy of this booklet, my lord, which has been served upon the detainee herein. This contains the document. This has it.
No, this contains a document that in fact he is also.
He
not
said
denied.
that at page 3, my lords, there is an FIR which has been referred, and the said FIR has not been provided to me to give the reply. But here, my lords, the document which is in my position says that there is a document. 417 is there in this.
In any case, who has
Even
provided
otherwise.
the documents, you have only provided the
Yes,
documents.
yes, my lords. Yeah, I have provided the documents. He has replied to that. He has referred the case numbers. He makes a detailed representation of every case. Without having a knowledge, he will reply on 417.
Even?
Has to be noted, my lords. The argument was that every detailed documentation should be given to the detainee, such that he will be having his chance to reply. And the argument continued that the 417 crime number was not given to him, which made him difficult to reply. But his detailed representation speaks even about the crime number 417.
About?
Crime number 417, which was not there in the list.
No, very well.
So, my lords.
What he has argued is first, the delegation of powers.
Yes, my lords.
So
Yes.
is it 23 or 24?
23 is the internal notification, my lords. 24 was the powers. Am I permitted to submit this document?
No, internal delegation is from which, according
Period of
to.
3 months, my lords, from
according-
10/6/24 to 9/9/24.
Why that 23 was added in the.
23 is an internal order, my lords, made within the government, delegating the power or extending the power time by time, my lords.
Enabling power to.
Yes, my
delegate.
lords.
Power, it appears, comes from the provisions of the statute also.
Please, my lords. A new government comes into picture, a new government formulates it.
Just see that, just show us that. man.
It's a notification, my lords. This notification, my lords, it
Give a
be
copy
extended
to
time
them
to.
also.
You can have a look at it. This notification confers the power to the district magistrate and the commissioner. Extended time to time. Here, my lords, it extended from 10/6/24 to 9/9/24. It's of 3 months.
Oh.
The reference number, my lords, is the main order, my lords.
No, the reference is that SST two.
Yes, SST 23/2023
After the formation of a new government, my lords, the government will be having its own part to form few regulations, based on which, my lords, in the month of June, my lords, it came to be passed.
What is that 23?
2023, the government was formed.
This
So
is only a
2023,
reference-
the government will be formed, my lords.
This is only a reference number.
It's a reference number. This reference will be used for every such kind of an order, my lords.
That's right. But the ultimate delegation is on 3/6/24 for a period of 3 months.
Please, my lords.
Kindly, my lords, what has been given as a delegation, very interesting, my lords. It's dated 3/6. And one nimsham, just you may be right.
Yes.
My lords, it's shown as 3/6. The 3 months for which it is given in the bottom, my lords would notice, 10/6/2024 till 9/9/2024. My order of detention, my lords, is on 10/6/2024. So which means, my lords, on the day the commissioner would get this delegation, sub-delegation power, my lords, is the day when he detains me. So he should have seen through the entire grounds of detention, having everything ready, waiting for this to come. On the first day when the delegation comes to him, is my detention order. So application of mine. That's why probably, my lords, that order of detention does not even know whether I'm a gunda or I'm a gambler. If the first day on which the delegation has taken place.
What you are saying is that it should be, the delegation is between the period 10/6/24 to 9/9. So it would be a period after 10/9, he starts applying his mind.
On 10/6, after
And have the
10/6.
material, maybe 10/15.
This is on the same day, my lords. That's why probably the detention order seems to be on much weak footing, my lords.
My lord,
10/6 morning I get arrested, detention order is given to me.
if I am permitted to, my lords.
Because normally when we,
However, that can be
You know,
seen.
Mr. Chauta, how the things
The
system
orders are passed on 3/6, my lords. He might have looked into, meanwhile, that his powers will start from 10/6.
Possibly he would argue is on 10/6 he had the power.
I understand.
From 10/6, he had power.
Normally, my lords, when
From
we
10/6
use
he
this
had
in the
power.
in the PC cases, my lords, one of the factors required for an investigation to be permitted after the registration of an FIR is the SP would have to independently apply his mind and pass an order permitting investigation to take place, my lords. So that time, my lords, we have found many cases on the same day itself, my lords, the FIR gets registered, same day order is passed under the second proviso under 17. And on the same day would be even the source report, FIR, and this order under 17. Where is the application of mind? So on similar lines, if its power has come on 10/6, at least they should have been little careful in saying 3 days we'll show we have considered the material. That's just in
But it's not like that. The commissioner is new to the seat, my lords.
All right, he also accepts how the things work.
Please. Coming to the next contention raised, my lords, the period is to be mentioned. My lords, your lordship may kindly look into section 3, my lords.
Your detention order doesn't give the time period.
It's not necessary, my lords. It's not necessary to specify the time period to be
Okay.
mentioned in the detention order.
Okay.
As my lords,
Section 3.
please, my lords. The clause 2 of section 3, my lords. In minutes that reads, my lords, any order passed in the subsection 1, my lords, shall not exceed 3 months at one time, unless it is been confirmed by the government, approved by the government within a period of 12 days. The whole of section C is this.
No, where are you reading? Section?
3 subclause 1 is the powers, my lords.
And the state government may, if satisfied with
Please.
respect to a bootlegger or drug offender, gambler or gunda, with a view to prevent him from acting in any manner prejudicial to the.
Now the order is now the order has been passed on 3/1. So subclause 2, my lords, if having regard to circumstances prevailing or likely to prevail in an area within local limits of jurisdiction of district magistrate or a commissioner of police, the state government is satisfied that it is necessary to do so. It may, by order, by writing, direct the during such period as may be specified in the order, such direct district magistrate or commissioner of police may also, if satisfied, provide in subsection 1, exercise the powers conferred by the subsection, provided that the period specified in the order made by the state government, unless this subsection shall not in the first instance exceed 3 months, may not exceed 3 months, but the state government may, if satisfied, aforesaid that it's necessary to do so, amend such order to extend the period time to time by any period not exceeding 3 months. But this is a fixed duration for 3 months, unless, coming to the next clause, so clause 3, where an order is made under this section by the officer mentioned in subsection 2, he shall forthwith report the fact to the state government, together with the grounds on which the order has been passed, and made such other particulars as in his opinion, having a bearing on the matter, no such order shall remain in force for more than 12 days after making thereof, unless the meantime it has been approved by the state government. So,
How would you read 2 and 3?
please, my lords, I read 2 and 3, my lords, that the maximum period would be three months if it is to be accepted by the government within a period of 12 days. If the government doesn't approve this detention order, then the maximum period 3 months, my lords, wouldn't sustain, my lords. Immediately, the said order will be terminated.
May not
If the state government doesn't accept the proposal of it within 12 days. Then again, my lords, within a span of 7 weeks from the date of detention order, the advisory board has to pass an opinion.
But at one point of time, it can't exceed 3 months.
At one point of time, he cannot make an order exceeding 3 months unless and until it is been approved by the government within 12 days. Thereafter, my lords,
Thereafter, the state government approves it.
it will be sent, it will be placed before the advisory board.
Pardon?
Thereafter, the state government approves it, it will be in force for 3 months unless and until the advisory board passes an opinion and that's been confirmed by the government. The confirmation vests to the government up to 12 months.
Where is the power for 12 months?
Please, my lords.
How are you reading 12 months in this provision?
I'm not reading 12 months in the provision, my lords. I
No,
just
what we-
continued
what
my
we-
argument to state that the maximum period of stress is 12 months.
What we have understood is this detention order,
Please,
12 days,
please, my lords.
approved by the state government, placed before the
Advisory board,
Advisory board gives recommend, state government accepts.
please,
This shall be done within how much time? 3 months?
please, my lords.
This whole process?
Yes, my lords.
Now, within 3 months, once state government approves it, for how long it gets extended?
The maximum of 12 months.
Where do we get that?
From, please, my lords.
Section, slight, may not be the right
Section 13, my
interpretation.
lords, Section 13 might be looked into, my lords.
Let's hear it.
But-
here.
Yes, my lords. It was, may not be the right interpretation, my lords.
No.
ಒಂದೇ ನಿಮಿಷ, subject correction then.
Okay, please.
Section 3 contains 2 aspects to it, my lords. One aspect in section 3(2) does not actually deal with the period of detention. It's only the period of subdelegation. The government can subdelegate to either the commissioner or the magistrate for a maximum period of 3 months, my lords. So we will not have to look into the detention period into it. It's only the power of subdelegation. So after 3 months, if they want to extend another 3 months, 3 months, 3 months. So that is insofar as subdelegation is concerned. But my lords, the detention order, if you have to see, is under 3(1). It says 3(1), they have the power to pass an order of detention. No period, my lords. Now, when it is done by the state government themselves under 3(1), my lords, the next step will be only before the advisory board, if it is done by the state government. But if it is done by the subordinate delegate, commissioner, then his order, my lords, will require an approval within a period of 12 days from the state government. This is how 3 is to be read. Now, once it goes, next step would be, my lords, it goes before the advisory board. Meanwhile, whatever representation,
The time period before advisory
my
board.
lords, we get that at 11, my lords, within 7 weeks it happens.
Within
11,
7 weeks?
section 10 is the reference to the advisory board. So they send it within 3 weeks to the advisory board. My lords, could I just read 10 and 11, my lords? That shows. My lords, 10 says within 3 weeks, it goes to the advisory board. And 11, my lords, disposal by the advisory board is within a period of 7 weeks. Then, my lords, action upon the advisory board, we get in 12.
Then 13 is the maximum period of detention.
Then
Please,
13,
13 is the
13,
maximum.
section 13 is the maximum period and 14 is a power to revoke. So at any point of time, even if you have done 12, if I give a representation, you find there's merit in my representation, you can revoke. This is how, my lords.
But even for a moment, the detention order doesn't say 12 months.
Yes, my lords. Initially.
Initially.
Yes.
Initially, it can't say so also.
Please, my lords.
Oh, it can, my lords.
It can.
It
say
can,
so.
it can. It
No,
can
but-
say,
Very well. Now let's understand it.
yes,
So that 3 months, what you are saying is the extending the delegation.
that's all, my lords. So 3 months will, because many a times, my lords, in fact, my lords, many a times when we also started with preventive detention, we thought 3 months is the maximum period. Then, my lords, on further study, we came to know it's
14
only
says 12 months is the maximum.
maximum.
13
Well,
months.
Section 13
Section
says
13
12
please.
months is the maximum.
That's the mandate. You can't go beyond that.
No,
No, my
not
lords.
more than 12 months.
Not more than 12
The
months.
absence of any detention period being there, will it be construed? It will be 12 months, not beyond that. Or can it be construed to mean if it is not there unless specified so? Can they say, instead of 12 months, they say 3 months? Can they?
They can.
They can.
They can.
If they have not said,
But lords, if they have not said, how I would interpret it is, when I give my representation, my lords, if I am not made known of what period I am being detained for, would it not be a case of saying you're deprived of a very vital aspect of knowing how long you're going to be detained? To that extent, I can use it for the detainee. They may say, my lords, Act does not say anything, so we don't have to mention. Their argument could be, my lords, under section, Act does not say that I have to specify initially period of detention. I will consider it later. But the problem happens here, my lords, problem that occurs is, my lords, when the matter goes up to the advisory board, on the basis of how the case has been built up, looking at whether it's petty offenses, serious offenses, heinous, or something which involves the security of the state, if the advisory board itself is not made aware, what is the period is being detained for? The whole process seems to be, because, my lords, ultimately,
more than that is, you will not have, according to, you may argue.
yes, please,
That you will not have a reasonable opportunity
please.
to oppose or contest the preventive detention unless that date is specified,
Unless the
period
date
is
is
specified.
Because, my lords, representation becomes a very key part both under Article 22, Sub-Article 5 and under this Act. The whole reason why they give it is for you to give a representation. Now, my lords, let's assume my preventive detention is only for 10 days. Only for 10 days. I may choose, my lords, if it is 10 days for the Act, I don't want to even contest it. I will go through my 10 days and come out. But if you don't specify the period, my lords, how would I assume till what time you want me in? This is how I.
Yes.
My lords, even Honorable Apex Court, my lords, on such kind of an issue, my lords, has clearly dealt with the matter and has reasoned it clearly, my lords.
We'll
There's
continue tomorrow, Mr. Chowdhury. We'll have it tomorrow as 5 items.
Please.
accomplished.
Tomorrow morning. You have to answer also non-consideration of the representation.
It's considered, my lords. It is considered.
But
It's been,
you
it has been,
replied back.
it has been communicated to the detainee. He has signed it. We do have the original record of it.
We'll see.
Oh, according to you have not got it?
No.
According to
his-
him, my lords, it's that he has not received it. But the document here, original document here speaks that he has been served a copy upon it and he has duly reduced his signature on it.
We'll see.
13th representation has been considered on 16th.
We have heard the Mr. Chauta, learned senior counsel for the petitioner and the SPP for some time to come up for further arguments tomorrow. Tomorrow. This is also this. Thank you.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 28 ಏನಾಗುತ್ತೆ?
ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಡ್ತೀನಿ ರಿಪ್ಲೈ.
ಮೇಡಮ್ ಒಂದು ನಿಮಿಷ.
Objection.
ಮೇಡಮ್ 18, 12, 9.
18
ಸೀರಿಯಲ್ ನಂಬರ್ ಏನ್ ಮೇಡಮ್?
28 ಮೇಡಮ್.
28
ನಾಯಕರು
29 ಮೇಡಮ್, ಸೆಪ್ಟೆಂಬರ್ 20.
ಮೇಡಮ್ ಅದು 20 ಸ್ವಲ್ಪ ನಾಯಕರು ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಇದೆ. 20 ಮೊದಲು ಅಥವಾ 23 ಆದಿಂದ ಆಗುತ್ತಾ?
28 ಆದ್ಮೇಲೆ ಹಾಕೊಂಡ್ಬಿಡೋಣ.
23 ಮೇಲೆ ಹಾಕೊಳ್ಳಿ.
ಒಂದ್ ನಿಮಿಷ. 23, 24, 9 ಮೇಡಮ್.
ಹಾ ಪರವಾಗಿ. 24, 9
28, 9 ಮೇಡಮ್.
ಆಗಸ್ಟ್ ಅಲ್ಲಿ ಇಲ್ವಾ?
ಮೇಡಮ್ ಇಲ್ಲ ಮೇಡಮ್, ಆಗಸ್ಟ್ ಅಲ್ಲಿ. ಅದಕ್ಕೆ ಕೊಟ್ಟಿರೋದು 29, ಸೆಪ್ಟೆಂಬರ್ 20 ಅದೇ ಇರ್ಲಿನ.
ಸೆಪ್ಟೆಂಬರ್ ಅದ ಪರವಾಗಿಲ್ಲ, ಆಗಸ್ಟ್ ಅನ್ಕೊಂಡೇನಾ? 29 ಅಲ್ಲ?
ಹೌದು ಮೇಡಮ್, ಸೆಪ್ಟೆಂಬರ್ 20.
ಓಕೆ ಮಾ, ಓಕೆ. ಥ್ಯಾಂಕ್ ಯು.